The Honorable Chief Justice and Associate Justice of the Supreme Court of California. Hear ye, hear ye, hear ye. The Honorable Supreme Court is now in session.
Good morning. Welcome to oral argument. Good morning. I understand we have visitors, so I'm going to announce them before we call the calendar so you know who's coming and going. And as I advised yesterday, we'll start argument when the noise quiets down between the change of audience participants. We have from UC Davis School of Law 7 students brought by their professor, Richard M. Frank, Professor of Environmental Practice. Are you here, Professor Frank? Wonderful. Thank you for coming. Nice to see you. We also have from Fresno City College, I'm not sure they're here yet, or all of them, 80 students from Robert Schmalley, the instructor of business class. Mr. Schmalley, thank you. Good morning. Nice to see you again. And we also have the California State Assembly Fellowship Group with Pam Chu, their program director.
Not here.
Not here yet? Okay, thank you. You may call the calendar.
Good morning. Supreme Court of California for the calendar. Session. And November 2nd, 9 o'clock. Case number S21-8066. Here is to all petitioners for the Superior Court Sanitary County responding. Case made, Joe Reynolds. This case is 3.9 December 2016. Case number S21-4058. Patricia A. Curry, plaintiff and appellant, for the State Bar of California, defendant responding. For responding is Danielle Garcia Lee.
Ready.
For appellant, Patricia A. Curry.
Morning, Your Honors. I'm prepared to go forward.
Case number S22-7393, Sheriff Felicity Gibran. Plaintiff responding was the Sharp Memorial Hospital, defendant appellant. For appellant, Mr. Jerry Budd.
I'm ready, Your Honor. Thank you.
For responding, Mr. Don Williams.
Ready.
And case number S22-8049, people plaintiff responding versus Billy Charles White, defendant appellant. For responding, Ms. Meredith White.
Ready, Your Honors.
Going for appellant, Raymond Mark Easton.
Morning. Ready.
We may proceed on Patricia Berry versus State Bar of California.
May it please the Court, Danielle Lee on behalf of the State Bar. The question is whether a trial court can't grant a special motion to strike pursuant to Code of Civil Procedure 425.16 if the defendant argues that one of the reasons that the plaintiff cannot show a probability of prevailing upon the merits is because the trial court lacks subject matter jurisdiction over the underlying causes of action. And the answer is that yes, it can. There are several factors that go into that conclusion, which are the purpose of the statute, the court's authority to determine contested jurisdiction, the factors that go into a trial court's analysis of whether a plaintiff can show a probability of prevailing upon the claim, and the court's ability to retain ancillary jurisdiction to control abuse of the judicial process.
I have a preliminary question.
Yes.
A SLAP motion was made in this case, strategic lawsuit against public participation. But is that the appropriate motion when the court lacks jurisdiction?
It is.
Are there other motions that would be more direct to the point that the court lacks jurisdiction?
I would submit that there are not. When you are talking about the category of lawsuit that passes the first test, the first prong of the test under the statute, these are lawsuits where a defendant has been sued in retaliation for having exercised their First Amendment rights. To add insult to injury, this person has been sued in the wrong court. So the fact that the trial court lacks subject matter jurisdiction is not a reason for the trial court to not consider a special motion to strike.
Could the same jurisdictional objection not be raised in a demur?
Of course it can be raised in a demur.
And so as in this case, if you have a SLAP motion and a demur filed simultaneously, how is the trial court to decide which to rule on?
So the benefit of a motion to strike under the anti-SLAP statute is judicial economy and protection for the defendant. Again, we're talking about a defendant who has been sued in retaliation for exercising their First Amendment rights. All of the protections that the statute affords, no amendments, no discovery, priority on the law and motion calendar, and fees if they prevail, provide judicial economy for the defendant.
I see that argument, counsel, and I see the larger point that you're making about the purpose of the anti-SLAPP statute, but I guess I wonder if any aspect of your argument is really rooted in a larger principle about jurisdiction. In other words, how much of your argument really simply turns ultimately on what the anti-SLAPP statute says and what its purpose is, and how much of it turns on what a court should be able to do, essentially irrespective of what the statute says?
So I would submit that both of those factors play into that decision. The first part is that a court always has the ability to determine contested jurisdiction, and it always has the ability to control abuse of the judicial process, regardless of whether it has subject matter jurisdiction of the underlying causes of action. So in the context of this particular type of lawsuit, again, we're looking for protection for the defendant, and we're looking to punish a plaintiff who files a frivolous lawsuit against someone who has exercised their First Amendment rights. But separate and apart from that, a court always has the ability to control abuse of the judicial process. Now, in a more generalized context, that happens in trial courts in the context of discovery abuses. The court has the ability to sanction both attorneys and parties depending upon their conduct, and the trial courts have the ability under Code of Civil Procedure 128.7. However, in this particular context, the courts have said that the traditional safeguards are not enough because winning is not a SLAPP plaintiff's primary motive. The primary motive is harassment, and it's to drain the defendant's resources.
Can I ask you a procedural question?
Yes.
That is, this case arises, I understand, well, historically, where Ms. Berry was disciplined by the state bar, and there were due process proceedings involved prior to the discipline. Thereafter, a petition was made to the California Supreme Court regarding a review of the discipline, and the Supreme Court denied review and discipline was imposed.
Yes.
At that point, Ms. Berry then sued the state bar in the trial court for discrimination and retaliation. So could those claims of discrimination and retaliation have been brought in the state bar proceedings at the time before either the hearing court or the review court?
In front of this court.
No, I'm asking her concerns, her underlying concerns about retaliation and discipline. Could those have been raised in the state bar proceeding?
Not at the hearing department level or at the review department level, but she absolutely had the right to raise them in her petition for review in front of this court when she challenged the recommendation for her discipline. So, and that would be the proper form to raise them as opposed to filing a lawsuit in Superior Court.
So can I ask you, so one difference between this case and your typical anti-SLAPP case is that in a case where the court lacks subject matter jurisdiction, and that is the basis for granting the anti-SLAPP motion, the judge hasn't really made any determination about whether or not the underlying claim is meritorious. So it's perfectly possible that somebody might have a genuine meritorious claim that just happens to have been filed in the wrong forum. Does that distinction make a difference in terms of thinking about the purposes of the anti-SLAPP statute and whether or not it is limited to investigations into the merits of the claim?
It does not. For the fact that there may be a scenario where a plaintiff has simply filed in the wrong court, and it's not a question of whether or not the case is completely frivolous. Again, that's not the case here. But in that hypothetical situation, a court could simply look at the first prong of the issue, and if this were not a SLAPP situation, then at that point they would never get past the first prong of the issue. This is not a case where we have a bankruptcy petition or a copyright infringement case filed in Superior Court where the lack of subject matter jurisdiction would be obvious on its face and it wouldn't be an anti-SLAPP situation. But in the event that this is a protected petitioning case and the trial court, when the trial court looks at the factors as to whether a plaintiff can show a probability of prevailing upon the claim, if the plaintiff can actually make that showing, but it happens to be the incorrect forum, then the trial court could simply deny the motion and point out that it's in the wrong forum.
What guidelines should we use when determining whether or not a given statute is either mandatory or directory?
With regard to the fees under the statute,
Yes.
in this case, the fees are mandatory. I don't recall when, but at some point the fees were optional, but then the legislature amended the statute to make them mandatory, because that fulfills the purpose of the statute. We want defendants who've been sued in retaliation for having exercised their First Amendment rights to recover their attorney's fees.
Now, in this case, the issue is whether the bar is entitled to attorney fees, is that right?
That's correct.
And the reason that's a question, as I understand it, is the anti-SLAPP motion wasn't granted on First Amendment rights or balancing the right versus the possibility of prevailing. The motion was granted on the grounds the trial court lacked jurisdiction. So am I correct?
So actually, the trial court, there were myriad reasons that this lawsuit was not viable in any way, shape, or form. And the trial court actually looked at all of those when it ruled that the plaintiff could not show a probability of prevailing on the merits.
It couldn't determine, if it had no jurisdiction, it couldn't determine any of the other grounds, could it?
Sure it could. And the reason is this. When you look at the language of the statute, Section B2 requires a trial court to look at all of the defenses that a defendant can raise when it's determining whether or not a plaintiff can show a probability of prevailing on the claim. And lack of subject matter jurisdiction is a defense. So that analysis can and should include every defense that's available for a defendant in its arsenal when trying to challenge whether or not a plaintiff can show a probability of prevailing upon a claim. And that includes a defendant's challenge to whether or not a plaintiff can state a legally cognizable claim.
So the issue here is whether the defendant, the state bar, was entitled to attorney fees.
Yes.
And under the statute, the prevailing party is entitled to attorney fees.
Yes.
And you postulate that you were the prevailing party.
Yes.
So what's the quarrel?
I would submit that there is no quarrel. There is a final, binding, unappealed order granting a motion to strike in this case. That order was never appealed. And then following that, the state bar filed a motion for attorney's fees. And under the statute, fees are mandatory. So I would submit that there's absolutely no problem with upholding the trial court's award of attorney's fees.
Well, I'm sure we're going to hear differently. So do you want to address what we're going to hear from the other side?
So one of the reasons that the plaintiff contested the trial court's ability to award attorney's fees was in part the subject matter jurisdiction issue. And because of this court's language in the Berrien case, where the court likened the motion to strike to a summary judgment-like motion. And it is a summary judgment-like motion in that it's a pretrial motion that can be dispositive of the proceedings.
How do you distinguish Varian, though? It's procedurally different. How do you distinguish Varian?
Varian is completely procedurally different. What Varian was looking at was whether or not the trial court proceedings should go forward while after the appeal of a denial of an anti-SLAPP motion was perfected. And since the whole point of an anti-SLAPP motion is to not have to go through trial proceedings, then this court held that allowing trial court proceedings to go forward pending the appeal of an anti-SLAPP was antithetical to the purpose of filing a motion to strike. And in that context, this court looked at whether or not a motion to strike was more similar to a motion for preliminary injunction or whether it was more similar to a motion for summary judgment. And the reason that this court picked the facets of the motion that are similar to a preliminary injunction is because in either situation, the goal is to be dispositive with the proceedings so that no trial court proceedings will go forward after that. But the fact that a motion to strike is summary judgment-like does not mean that it's a ruling on the merits in the sense that for res judicata purposes. So a motion to strike is actually unique. In Varian, this court focused on the similarities to a summary judgment motion, but it really has facets that are similar to many different motions, to a demur, to a motion for judgment on the pleadings, to a motion for preliminary injunction, and to a summary judgment motion. And in fact, the second step of the test actually involves two parts. The first part is whether a plaintiff can show a legally sufficient claim. That's the part that's more like a demur. And the second part is an additional hurdle where the plaintiff has to show a prima facie set of facts to support that claim. That's the part that's more summary judgment-like. But if a plaintiff cannot show a legally sufficient claim, then there's no reason to reach whatever additional facts the plaintiff has, because at that point the plaintiff cannot show a probability of prevailing upon the claim, no matter what facts they have.
So I'd like to return to answers that you gave earlier that suggested that the procedural path might be different. First, in a case in which it's clear on its face that there's no subject matter jurisdiction, you suggested that a court could decline to grant the motion to strike under those circumstances. And second, in a case in which there is not the same degree of, there aren't the same findings about the substantive merits of the claim as in this case, you suggested that where there's no determination of whether or not the substance of the suit is frivolous, then under those circumstances a trial court could decline to grant the motion to strike. And I'd like to hear more about your thinking on those 2 points, because as I understand your argument, it's that the anti-SLAPP statute says that where the plaintiff fails to show a probability of prevailing on the claim, the trial court must grant the motion, which would seem to apply equally in those other 2 situations that I've mentioned.
So the other situations that I was mentioning, I thought at that point you were asking me about otherwise punishing a plaintiff who might actually be able to show a probability of prevailing upon the claim. And my point was that the statute by its nature will not apply to 2 categories. It will not apply to an innocent filer who is filing a case that has nothing to do with protected petitioning activity, nor would it apply to a plaintiff who may be filing a lawsuit that has to do with protected petitioning activity, but can otherwise show a probability of prevailing upon the claim.
And how would, if the plaintiff has filed that claim in a forum that has no power to grant the plaintiff whatever relief he or she seeks, how could he or she show a probability of prevailing on the claim?
So the two examples that we cited in our brief are not anti-SLAPP cases, but in the Brown case, the exclusivity of the workers' compensation system was at issue in that case, and then in the Singletary case, the exclusivity of the Employee Relations Board was at issue in that case. So in both of those cases, it was not whether or not those lawsuits were frivolous, it's just that they belonged in a different forum. And without speaking to the merits of those particular cases, it's entirely within the realm of possibility that some variation of those fact patterns could include SLAPP causes of action, but could include an ability to show a probability of prevailing upon the claim, but in a different form.
And why would that be relevant in terms of how you're thinking about how the anti-SLAPP statute ought to be interpreted? So how would you define what it means to prevail upon a claim in a situation where the trial court has no power to grant the plaintiff any relief because it is the wrong forum?
So it would depend upon the claim. Again, that's not the case here. We're dealing with a case that had no merit whatsoever. But if you allow a trial court to look at subject matter jurisdiction in the second step of the test, that allows a trial court to look at the viability of the lawsuit in general, including whether it's in the appropriate forum and whether or not there are other claims where the plaintiff might be able to show a probability of prevailing. So that furthers the intent of the statute in that even if you find that this is a lawsuit that is part of that larger category of SLAPP situations, if you let the trial court look at both subject matter jurisdiction and just the viability of the lawsuit in general, in that context, it can make those determinations.
It seems at least a little awkward for a court that has no jurisdiction to engage in that kind of analysis, don't you think?
It's actually not. So if you look at the statute, Section B2 says that the trial court needs to look at the pleadings, and it needs to look at the defenses, and it needs to look at whatever facts both parties can put forward. So the trial court is taking a holistic look at the viability of the lawsuit. It's not necessarily making a ruling for res judicata purposes, but it needs to look at whether or not this lawsuit is viable and whether it has any merit whatsoever. And only when the lawsuit is completely lacking in merit in any way, shape, or form are sanctions under the statute appropriate.
Now, just to clarify for me, in this circumstance, hypothetically, the allegations might have had merit, but this forum was not the one that could rule on it. So going, I think, a little bit back to Justice Cuellar's question and an earlier question of mine, if the court lacks jurisdiction, it lacks the capability and the appropriateness of even evaluating the merits. And so I think that's a distinction from what you were saying, that assesses the pleadings and the defenses and so forth. The case might actually have merit in the correct forum, right?
In the abstract, yes. That's not the case here. There were myriad reasons that this lawsuit had no merit whatsoever.
But how do we know that?
So, again, if you look at the language of the statute, the statute does not require the trial court to reach the merits of the claim. We're talking about probabilities and claims. And that includes any defenses that a defendant wants to raise.
So in this case, the probability of prevailing in the trial court was nil because
right.
the court had no jurisdiction.
That's exactly right.
But that doesn't address the probability of the merit in the proper forum, which you said was before this court in an earlier proceeding.
Yes, to the extent that the plaintiff wanted to make challenges to her disciplinary recommendation, this is the proper form. It was the proceeding that was transmitted from the state bar court to this court. She was allowed to have that opportunity to raise those challenges there. And
so that was my original question. And I understand originally that Ms. Berry stipulated to the discipline and thereafter declined to follow through with the stipulation, which caused the state bar court to bring the formal proceedings that resulted in the discipline.
She stipulated to findings of fact and conclusions of law and a predicted disposition of, I think it was a 60-day suspension. But then, yes, she challenged that, and she filed a petition with this court to challenge that. That was the proper form to make those challenges. So I believe I've used up most of my time, so I will.
You'll have 10 minutes for rebuttal.
Thank you.
Good morning, and if it pleases the court, my name is Patricia Berry. I'm representing myself. In terms of the underlying lawsuit, this was not a good case to bring to this court because I malpracticed myself. I was beaten down, felt horrible about the discipline imposed on me because I represented a battered woman in federal court. And to be candid with your honors, had I known about what would happen with the Girardi Lack fiasco, in which the state bar actually insulted 3 judges of the Ninth Circuit in a reported decision, making an explicit finding that Girardi and Lack had misled a federal judge of the Ninth Circuit, and the state bar actually insulting the Ninth Circuit and saying these men did not mislead a federal judge.
Ms. Berry,
Yes, Your Honor.
we have a very narrow legal issue to decide here.
Well, I think
and it
that
will be helpful to us if, as a trained lawyer, you would address yourself to those issues and those issues
all right.
focused.
All right. Thank you, Justice Corrigan. That segues into her claiming, that is Ms. Lee claiming, that my lawsuit had absolutely no merit. Assuming that even a governmental entity has free speech, which I find doubtful, and I intend to challenge that in the federal court. It makes no sense. Free speech comes from people who are citizens, or in this case, a member of the bar, challenging the validity of things that have happened to them. The speech of the government is not free. But in any event, what I want to talk about is the complaint. Ms. Lee talks about only the petitioning activity. I suppose she means the prosecutor went after me in terms of my discipline. I also brought up to use her language, she talks about the host of structural changes. That has nothing to do with petitioning activity. This
So
is.
can I interrupt you?
Yes, Your
I
Honor.
understand the issue on appeal for us is pretty narrow, and that is that you're not contesting that the lower court lacks subject matter jurisdiction. What you're contesting is the award of attorney fees.
Well, the award of attorney's
I mean,
fees.
is that right? I mean, that's what so we're not talking about, we're talking about whether or not, I mean, I understand that you didn't petition for review to ask us to review subject
That's
matter
right.
jurisdiction,
I was
right?
brought here kicking and
Right.
screaming.
So subject matter jurisdiction, we assume for purposes of the issue before the court, isn't before us. The issue before us is whether the court, assuming lacking subject matter jurisdiction of the lawsuit, could still award attorney fees under the anti-SLAPP motion.
My argument, of course, is that's impossible because it's if you lack subject matter jurisdiction, which Her Honor at the trial court level determined she had no subject matter jurisdiction. But as I recall her opinion, she kind of did a mix and match. She would talk about, I don't have subject matter jurisdiction, but by the way, Ms. Berry does not have a claim and does not have a probability of success under the 425.16. Now, the 425.16 is a very special motion that was designed to protect the residents and citizens of the state of California, not the government. But having said that, and assuming for the moment that the bar has a right of petitioning activity and has some free speech involved, Ms. Lee, on behalf of the bar, had to go through that analysis. In other words, you can't get to, you can't pass go, move over to the money until you've convinced the judge that you have a cause of action based on your petitioning activity. That is a substantive analysis. Furthermore, the 425.16 SLAPP does not confer subject matter jurisdiction to determine subject matter jurisdiction in an anti-SLAPP. An anti-SLAPP motion is just that. If you're getting slapped, then you get into the analysis. And Ms. Lee has conceded that there is a sort of motion for summary judgment analysis where she filed her papers and said, look, Ms. Berry's coming after the bar based on our free speech activity, which I guess she means the prosecution, which is a form of petitioning activity. And then I would respond if I had and showed, even showing that, I have a probability of success by, in this particular case, showing that it was a mixed.
But I think what's at least confusing me, maybe some others, we never, since the trial court lacked jurisdiction to evaluate your probability of success or whether the bar has a free speech, the trial court had to dismiss the action because it had no jurisdiction whatsoever. And as I understand it, that having been the case, assuming no evaluation of the merits occurred, so the court has no jurisdiction, but it yet went on to say, I have no jurisdiction, this lawsuit is dismissed, I'm awarding attorney fees to the bar. Because the bar, and I'm quoting the theory, the bar prevailed, it got rid of this lawsuit in this court. Am I correct?
That's correct.
And so that's what we have to decide is whether when the trial court has no jurisdiction whatsoever to rule on the merits, can it still act to award attorney fees to the party who wanted that case dismissed?
Well, Your Honor, in order to, the award of attorney's fees was made under 425.16, not under 430.10, which Ms. Lee, 430.10 of the Code of Civil Procedure. Ms. Lee pled that she had filed a demur and she alleged CCP section 430.10A, the court has no jurisdiction of the subject of the cause of action alleged in the pleading. She did not seek attorney's fees there. The award of attorney's fees, as I understand it, was made specifically under the provision in the anti-SLAPP.
And did the state bar prevail in the anti-SLAPP motion in the sense that the case didn't go forward?
It can't prevail. In other words, I'm arguing it's not possible. It's
Your view is that it has to prevail on the merits in some way.
That's right. I'm saying that these are two separate doctrines and that the first thing that a court must do is to determine, do I have subject matter jurisdiction? And I think as Her Honor has indicated in questioning Ms. Lee, you can have entirely meritorious claims. Happens all the time with in federal court with the Rooker-Feldman doctrine. That's thrown at us civil rights attorneys all the time. That is not saying that the claim is not meritorious. That's not what they're saying. They're saying, I'm sorry, the matter had been decided in a state court and you're in violation of the 1790 Judiciary Act.
Prevail, in your view, in the statute means prevail on the substance of the lawsuit.
Correct. And the 425.16 can't confer subject matter jurisdiction to consider subject matter jurisdiction.
I understand. And that's what we have to decide.
I would say so, Your Honor.
Can I ask, so the words of the anti-SLAPP statute that we're particularly concerned with are the provision that requires the plaintiff to establish a probability of prevailing on the claim. And I guess that the central question for you is how can you establish a probability of prevailing on a claim that has been filed in a form that has no power to grant you the relief that you're seeking?
Well, that would be my position, is that if at the threshold, and this is a threshold issue, the judge has to first determine, once subject matter jurisdiction is challenged, which Ms. Lee did in her demur, got to stop and take a look at it. That's what the judge in San Francisco did. Ms. Lee was on that case with the poor Phil Kay. And the judge says, the San Francisco judge said, got to take a look at subject matter jurisdiction. Ms. Lee has raised that. I agree. No subject matter jurisdiction. You're out of court. The anti-SLAPP motion is moot because he...
And that answer assumes a conclusion that I think you haven't adequately justified. So that assumes that the anti-SLAPP statute doesn't permit a judge to grant a special motion to strike precisely because the court lacks subject matter jurisdiction and so has no power to grant the plaintiff the relief that she's seeking.
That's my argument. Because of the way the language and the structure of the statute itself, the structure of the statute says that the moving party must establish that they have a cause of action brought under that involve free speech or petition activity. Ms. Lee did that at least for half of the case. This was really a mixed case, but I'm not going to get into that because, I caved. But the most important thing is she has to do that, but then having raised that, I had a due process right to get into the merits of the claim. But the court had already said, or did a kind of intersperse, I don't have any subject matter jurisdiction, but continued to do somewhat of a factual analysis as to why the anti-SLAPP motion should be granted. And my position is that if the structure of the anti-SLAPP motion itself, Your Honor, is worded where the moving party has to present facts, has to present a cause of action, you can't prevail because you're going after me for these reasons. They're entitled to put on affidavits. They could have gotten the affidavit of Brandon Tatey, whatever. And then I have a right to put on my affidavits or declarations, exhibits, and so on.
But what if it's a situation in which it's not necessary to look at any facts that might be adduced or any affidavits that might be introduced in order to establish, let's abstract this away from your particular case, but what if the trial court doesn't need to look at any of those things to know that the plaintiff's claim has no merit?
Then they grant the motion. But what I'm saying in this particular case, the anti-SLAPP motion is not built, is not structured, was never intended to resolve the issue of subject matter jurisdiction like a demur. Now, Ms. Lee...
I guess the question is, why do you say that? I mean, it seems to me that the fundamental purpose of the anti-SLAPP statute is to ensure that the termination of the lawsuit is accelerated in order to avoid chilling the free speech rights of the defendant in the meantime. And that could be a termination that's sort of based on the summary judgment-like procedure that involves a look into the facts of the case, but it also could be a termination that's based on other grounds for dismissing the lawsuit.
Well, Justice Kruger, what I would say is that demur is a lot faster. You can get heard in 45 days. With an anti-SLAPP motion, she could have answered and she had another 60 days to file it. Furthermore, then it gets into taking up the court's time with analyzing and going back and forth. And had I done my job, I could have possibly prevailed in the anti-SLAPP because it was clearly a mixed case. The question was a non-petitioning activity, free speech activity, overcome by the fact that I was challenging the structure of the bar. This case was really about the bar. It also involved my discipline. And I'm not going to get into the merits of the discipline. I intend to raise that in the federal forum for a second time because I don't think there's anybody in this courtroom would say that the court needs to take a close look at the bar and what's going on there. But having said that, what I have, at least in my training as a lawyer, is to look at the statute 425.16, and it was specifically designed to give an opportunity to litigate the merits in an accelerated proceeding, and that if the moving party, the defendant, can prove to the satisfaction of the court that the facts, are in her favor or his favor, then they win. This was actually kind of gummed up the works. She had a demur on calendar, should have been looked at, it was looked at, and then somehow the court moved into the anti-SLAPP, which...
Let me ask you a related question.
Yes.
In this case, the demur and the anti-SLAPP motion were filed at the same time?
Yes, Your Honor.
And they were scheduled by the court at the same time? They were both on the calendar at the same time?
I believe so.
All right, so what you are arguing in essence is that in such a circumstance, the court must consider the demur first before it moves on to the anti-SLAPP motion, and if it finds that it lacks jurisdiction, that's it.
Yes, that's my position. That's what I understood the Court of Appeals who ruled in my favor.
Well, we understand that. We can just stay focused on where we are. So there is a general principle that the court has the authority to manage its own calendar and to consider issues in the order that it finds most appropriate. What you would have us do in part is say that general proposition doesn't apply when there is a threshold challenge to the court's jurisdiction, period. Right?
I would say so, Justice Corrigan, and also, Your Honor, again, it slowed down the works. Once the court...
We understand that, Ms. Berry. I'm just trying to focus on the legal question that we have to resolve here. So you would agree that that would be the effect of our rule, whether we say it that way or not, that in a circumstance such as this, the court must consider the demur first.
It must consider the demur based on subject matter jurisdiction. Yes.
Thank you.
All right. If there's no further questions, I'll turn it over to Ms. Lee.
Thank you, Ms. Berry.
Thank you.
So just to clarify for the court, public entities are protected under the anti-SLAPP statute. That's the Bradbury case. And just a couple of points in response. The first is that subject matter jurisdiction is not fraud. It does not vitiate everything that it touches. The fact is that a defendant is not limited as to the timing or the manner in which it raises that issue to the court.
But there is some, at least surface appeal to your opponent's position that if you are challenging the jurisdiction of the court, period, the court should consider that threshold question, which is almost always a threshold question if it is in debate, and that you filed a demur, you said the court didn't have jurisdiction, the court should have ruled on that, and that'd be it.
So we are talking about only a subset of the cases that are already qualify as cases that are brought against the defendant in retaliation for having exercised their First Amendment rights. Allowing a defendant to argue lack of subject matter jurisdiction provides judicial economy for the defendant. And again, because a defendant does not have to raise...
Would it be right to say that your response to your opponent's position is that the whole purpose of the anti-SLAPP motion is to grant relief to a wrongfully sued defendant, as the anti-SLAPP statutes conceive of that litigant, and that to allow someone to sue a defendant in the wrong forum should be a circumstance that gives rise to anti-SLAPP protection.
That's exactly right. Again, these are people, as Your Honor said, who've been sued in retaliation for having exercised their First Amendment rights. It provides the protection of the statute, judicial economy for that defendant to allow them to argue lack of subject matter jurisdiction in that context.
Well, let's be honest with one another. It's all about the fees, right?
It's
Because
not
you could get the same remedy in terms of getting out of court on a grant of your demurrer.
It's not about the fees. I think this case is about the fees. That's what the court granted review on. However, there are other benefits that the statute affords that are very important for judicial economy and for protection for the defendant, which is there are no amendments pending the ruling on the motion. There is no discovery. And so, and then anti-SLAPP...
Well, but if there is a challenge to the court's jurisdiction at the threshold, I would think there would be no discovery until the court rules on that essential question. Wouldn't that be right? Or have I completely lost track of my civil procedure, which is also possible?
So say a defendant files a demur. They can no longer file an anti-SLAPP motion because they're arguing lack of subject matter jurisdiction. They no longer have priority on the court's calendar. It could take months for that demur to get heard. In the interim, they could be subject to an amendment of the complaint, and they're subject to discovery.
I get it.
Okay.
Thank you.
Are there cases that you can imagine in which discovery would be necessary to determine whether or not the court has subject matter jurisdiction?
Of course there are. However, if we're still talking about a case that involves protected petitioning activity, then the plaintiff can move to lift the stay of discovery in order to obtain the discovery that it needs in order to oppose the motion to strike. I believe I've touched on all the subjects that I wanted to, so unless the court has any other questions, I will submit.
Thank you, Ms. Lee. Ms. Berry, the matter is submitted. May proceed on birthday for Visite Cabron versus Sharp Memorial Hospital.
Thank you, Your Honor. May it please the Court, Jeff Doggett for Petitioner Sharp Memorial Hospital. We're really here today to decide the jurisdictional nature of the mandatory, or I should say the aggregate time limits of CCP 659A. The petitioner would submit that when we look at the language of the statute, the legislative history, and the judicial interpretation of that statute, that we would conclude that exceeding the deadlines mandated by that statute would make a court order void, and therefore it is, in fact, a jurisdictional issue. We would submit that that is, in fact, what occurred in this instance. This court in Abiera versus District Court was one of the first to address this distinction of jurisdiction, meaning that at the extreme end we have a lack of subject matter or personal jurisdiction wherein the court cannot consider a matter at all, versus a situation where the court is acting contrary to statutory authority conferred by the statute.
Counsel, given statutory authority here, aside from the use of the word shall in 659A, which I grant you is an important word, but let's leave that aside, what else about the statute supports your argument?
Your Honor, I think that the Erickson court pointed this out as well. If you go to the real issue in this case, which is the aggregate time limit, meaning after the maximum extension is granted of 20 days for the party to file papers, it says that the court very specifically may not exceed that extension. And so you have very clear language that directs the court saying that if papers are received after that extension, that they simply cannot consider it because the face of the statute itself says that the extension may not exceed that 20 days, now 10 under the existing statute. And when you compare that statute to 659, I think it makes even a more emphasis of the importance of that language. 659 for 101 years since that language was put in 1950 has been held by all courts to be jurisdictional in nature, and that failure to comply with 659A, failure to file the notice of intent within 15 days of the notice of entry of judgment, is a void order. It is a nullity, and the court cannot consider those papers for further proceedings. Yet 659 only uses the word shall, as Your Honor has pointed out, to confer that interpretation and to allow courts to make that determination. I would submit that 659A actually takes it a step further by adding the language that we just addressed at the end of that statute, again, directing the trial court that they do not have the authority to exceed that extension, which is exactly what happened in this instance. The real issue here, when we're talking about whether something simply affects jurisdiction or is in excess of jurisdiction, as had been articulated by the court, is we have to determine, again, let me back up, excess of jurisdiction through Abiera is the authority to act except in a particular manner. In this case, the particular manner that you must act, the court is required to act, is to deny the motion because the mandatory time limits of 659A have been exceeded.
Counsel, how do you distinguish this from statute of limitations?
Well, Your Honor, the statute of limitations, there can be stipulations that of the parties to extend the statute of limitations. And it has been found over the years that it is not a void, it does not void the action if, in fact, the parties or there's good cause to extend that. There are other statutory provisions that also allow the extension of the statute of limitations by way of tolling and other issues of good cause. In fact, that is not the case with the motion for a new trial.
What is the underlying policy reason there? I mean, forget about tolling. I mean, just if there is no exception or rescuing provision for a late filed complaint, why haven't courts, and the other side doesn't object, why haven't courts determined that to be not in excess of jurisdiction, but lacking in jurisdiction fundamentally?
Your Honor, there is good policy reason for that decision on a statute of limitations, and it happens quite often in civil litigation, and that is that the parties are, for example, trying to resolve the matter short of litigation, and they often extend stipulations beyond the statute of limitations to allow for settlement negotiations or additional discovery in a pre-litigation phase to resolve the matter without resorting to litigation. And so there are very good policy reasons in that instance for not deeming that it is a mandatory statutory violation. And I think that that actually promotes justice, it helps the judicial system, it helps overburdening the judicial system, and it benefits as a cost-saving measure for the parties. It's simply not the case in this instance. This is much different and has always been interpreted to be a void order. And again, if this court in People v. Laura gave us some guidelines for making a determination when we have a statute that is in excess of jurisdiction as to whether to treat it as mandatory or directionary. And there they said we must ask the question again if a violation of that mandated language makes the order void versus voidable. And to make that decision, we are supposed to look at the statutory language in question the intent of the legislature in enacting those statutes, and again, the judicial interpretation of those statutes.
What's the policy concern here then with late filed affidavits?
The policy
if your client did not object, which it didn't below, at least that's what it appears. What's the problem? Why would a court be concerned about that? I mean, I think the logical implication of your position is that the court, on its own initiative, right, would have to have spotted that issue and declared itself, unable to rule on the new trial motion. Why would we burden courts with that when the parties are the ones most alert to this, and this is, this is an issue that's in the course of the litigation, something that everyone ought to be alert to.
Your Honor, I think that one misunderstanding about the facts of this case that perhaps occurred also in the district court, although the record is very clear on this, is that the petitioner, as well as the court, did not have notice of the fact that these papers were not timely filed. The only party that had notice of that was the respondent, because the documents served on the petitioner indicate timely filing on the 2nd of April. The papers had to be refiled on the 5th, and they were never reserved on the petitioner. And so it's not that the court has to take on that burden, but the petitioner in this instance could not take on that burden because there could be no knowing waiver, as is required in the law, that you were knowingly relinquishing a right or a benefit, because there was no way to have knowledge if the petitioner if the respondent, decided not to give notice of that.
Well, I know you dispute that point based on the record, but setting that aside for 1 second, I mean, it is still the implication of your view that the trial court would have to be alert to this issue, right? I mean, otherwise we'd have these appeals all the time and people have to go back and do it over. So the point is that at the trial court level, there is some burden put on the courts to figure this out on their own initiative.
To the degree that that's necessary, and let me address that in two areas. If we agree that the trial court has a burden to be aware of that, it is a simple matter of opening the file and looking at the file stamp on the documents. Because when we have the hearing up in the department, in this case, 7 days after the late filing, that file would be before the court. And the file stamp of when it was received would be on the face of the document. So the burden would not be that excessive in that entrance. Secondly, because there is no knowing waiver here, and because an objection in this matter would not have made a difference and would have been futile, because we're talking about a deadline that is already passed, which can't be cured by objection, that I would indicate that when that is discovered at a late date and the unusual circumstances of this case, meaning, again, it was only discovered when the record of appeal was being compiled in this case, and that's when it was brought up for the very first instance in the only court that had jurisdiction of this matter at that time, which was the 4th District Court of Appeal. That in fact, it does not constitute waiver because, again, there was no knowledge. And so I believe waiver is not applicable in this case for that reason. But it's also not applicable in this case because when we look at the specific language of the statute and when we look at the case law that's interpreted that statute, an order that violates the aggregate limit of 459A is void. And if it's void, the court's held that the court simply cannot consider the papers at all. And if the papers are a nullity, then there's no objection necessary. The motion is denied. And in fact, the Supreme Court has specifically so ruled in Hicks v. Ocean Shore back in 1941. And again, this decision came down only 6 months after the Abiara case, and they held that affidavits not filed in the time frame of 659A or an extension thereof do not properly constitute a part of the record. And so this body has held, in fact, the jurisdictional and mandatory nature of complying with that statute. They have indicated that failure to file is void. I would also point out that all the district courts preceding the Erickson decision, which is the decision that the 4th District Court chose not to follow in this instance, have used the same delimiting language. In Sakai, cannot serve as the basis for a motion if they're late filed. In Leawood, the court would not be justified in considering them. In Crespo, they are not to be considered by the court. Terry, late decks made the motion beyond the court's authority to grant and must be stricken. And in Maple, the judge erred in considering them was an abuse of discretion.
Okay, can I ask you about that? So I think a lot of your, rightly, I think a lot of your argument centers on the structure of the statutory scheme, looking at 59A in conjunction with 59 and 60 as well, right? In the sense that I think you read the statutes in an interlocking manner.
Yes.
Right. What about the argument that 659A doesn't really contemplate the parties having kind of symmetry with respect to the time they get, because if all the parties took all the available extensions that were available to them, that would be beyond 60 days. So the notion of sort of fairness in terms of the allotment of time for each side to put forward their arguments and their materials for this new trial motion doesn't really fit within the 60-day period anyway, which is a hint that the 659A scheme is not really meant to interlock with 659 and 660.
Your Honor, I think that is true to a certain extent. Even with the most recent amendment, where they're trying to cure that at least to some degree, they still didn't quite get it right, because the new statute it implies that you could also get a 10-day extension for the reply, and if you did that for all three of the motions, you're at 70 days instead of 60. However, while it doesn't make it completely equal for the parties, at least the construct of the statute did at least give minimum times for each party to respond, which again was a violation in this court. And if you look at this in a broad sense, if we're going to give the court even additional discretion by saying this is only directory, then not only does it almost always prevent the prevailing party at trial from getting 30 days or now 20 days to do an opposition, but it often impedes them from even getting the mandated statutory minimum of 10 days to complete their opposition. And that's the aspect of it that is in compliance with the entire statutory scheme. We have at least minimum days that we need to give each party to respond and to provide supporting evidence so that the court can make a reasoned and intelligent decision on the motion for new trial.
Say that again. So the non-moving party here will not get the minimum?
In this case, the non-moving party did not get the minimum. And if we give the court even more discretion to accept late-filed affidavits, yet we still are bound by the 60-day limit of 660, which again, completely jurisdictional, that's been held over the time. We could actually reduce the minimum time by giving even more discretion to the trial on that to a day or even two in order to meet the 60-day deadline, which is exactly what happened in this case. The court was faced with a dilemma that to make the 60-day, they had to cut off the time for the prevailing party at trial to submit affidavits to try to defend the jury verdict and to gather evidence to do so. And again, we have to give deference at least to the legislature that there's got to be a minimum of at least 10 days for the prevailing party to submit that evidence.
So, counsel, these seem like all really good arguments to make at the trial court level when you've had an opportunity to review the documents and place the timing and the time stamp and the filing of the declarations, because what you say makes terrific sense. Yes, you need the days, and yet that didn't happen to the trial court. So the trial court wasn't in a position to say, well, in light of these and in all fairness and good cause, I am therefore going to disallow these two doctors' declarations. But none of this was raised with the trial court in order to try to then form some equitable division of the time left in order to meet the 60 days for the trial court to rule. So you're telling us here of the parade of horribles, but there was no objection below. And there was an objection in Erickson, but not here. And so when we read this purely statutory scheme, because new trial motions are purely a creature of statute, courts have no authority on their own to start a new trial motion. It requires strict adherence to the plain language of the rules that everyone must play by. And I'm still, I suppose, and you could say this again to me, why it is where it is in 659 and 660, the legislature has clearly said that when the court loses jurisdiction. But in 659A, the statute we're primarily concerned with here, it didn't say that.
Your Honor, I think that your point is well taken with 660. The legislature did clearly use the term as to what the jurisdictional limits were of 660. That is not the case with 659.
659A.
Right, Your Honor, but in terms of the statutory scheme, why this one is different. It's not different from 659, yet they've held the same mandatory construction of those time limits, just solely based on the word shall. And so to say that 659A, which contains that word, plus the additional language that the court may not exceed the time limits provided by that statute, is more determinative than 659 for making a jurisdictional determination that the time limits cannot be extended. And to your point in this case about the fact that an objection wasn't raised, that is true, Your Honor, because there was no knowledge of the late filing until after the record on appeal was produced. At the hearing of the motion on the 12th, the respondent did not tell the court, by the way, the papers were rejected. They were not filed until the 5th. And the court, who had the file in front of them, didn't say it. The late file papers were never reserved on the petitioner in this case. So how could there be a knowing waiver by failure to object when there was absolutely no knowledge of the fact that the papers were filed late?
But wasn't there a concern that you didn't have enough time?
There was a concern about...
And was there an objection raised that we didn't have enough time?
There was an objection, yes, raised when the court limited the motion, the ability to respond to 7 days. That objection was raised at the ex parte hearing. But you raised the objection, and the court, who had no choice at that matter in the judge's mind, because of the 60-day limit, prevented the party from having the requisite time. And I would submit, Your Honor, that it's not...
So can I back up and ask a procedural
Absolutely.
question? So you knew you only had 7 days, but you knew you were entitled to 10. So what do you think happened to those other 3? I mean, why weren't you objecting that you were entitled to 10, but for some reason you had 7? I mean, those are the kinds of strange irregularities that get worked out in a trial court. You pull up the documents, you compare the dates, you recreate the paper trail as to why you're here. You knew you had only 7 days, but what did you think happened to the other 3? I'm just trying to understand.
Your Honor, we didn't know that we would have 7 days until the ex parte on the 3rd. The client did not know that then, until the 3rd. What the court's options then were to violate the statute, either 660 or violate 659A. And I would submit that it's really the...
So you mean violate 659A?
By not giving 10 days to respond, versus 660 by not allowing the hearing to occur in 60 days. But Your Honor, I would submit that that really is the responsibility of the moving party. They're the ones who want the motion granted. And the responding party, obviously, if the motion's denied on jurisdictional grounds, prevails. And when the moving party wants to set those time limits, recall that the stipulation here, the agreement, the contractual agreement of the parties, was that the respondent had up until April 1st to file their papers. That would be the last day of the full amount of the extension. Because of the court holiday, that happened on the 2nd. But even without that, the real papers were filed on the 5th, still not in conformity with that. But
At what point, I guess I'm still stuck on this. At what point did your client, did your client become aware of the late filed affidavit?
When my client was preparing the record on appeal for the motion for a new trial, the original motion for a new trial was based on the substantive ruling of the court that the new evidence did not constitute additional evidence and that it was cumulative. And so that was going to be the original reason for the court for the appeal. When we were getting the record on appeal is the first time we saw the file stamp that the clerk made that was never served on the petitioner.
You're saying the April 5th refiling was never served?
Never served. And that is clear in the court docket. That is submitted as evidence here. The court docket shows when those occur. The appendix shows that the only proof of service on the petitioner was on the 2nd, 3 days before that incident occurred. And then even if it wasn't served, it was not brought up at the hearing. to give notice to the other side that that has occurred. So there was never an opportunity to object. And that is why it almost sounds in unclean hands, and I don't want to cast that type of stone here, but to now say that you have waiver when there's no notice of the fact, and the only party that had notice of the fact was in fact the respondent at the trial court level.
Well, let me ask you then, I mean, in the progression here, sometime between April 1st, which was the date everybody was aware of, right?
Correct.
But that was a holiday, right? So
That's
April 2nd was the next court date.
Correct.
So sometime between April 2nd and April 12th, when the new trial order was granted, Sharp filed a opposition, didn't they? Didn't it?
It did.
In the trial court.
Yes.
And at that point, it was aware of the affidavits?
It was aware of the affidavits, yes.
It just wasn't aware that they were late stamped, that the filing fee had not been paid and that it was refiled on the 5th?
That's right.
Okay. So, so you're saying that in the trial court, Sharp was operating under the impression that the opposition, I guess it was due, my papers say, April 10th, is that right?
The opposition was due April 10th on the shortened notice by the court of 7 days.
Short notice by the court of 7 days. So at that point, there was no objection made? As the Chief Justice asked you, there was no objection made that you were entitled to 10, but you only got 7?
There was an objection made at the ex parte when he set the briefing schedule. But
When was that?
On the 3rd. But the court said, I have no option because of the 60-day limit. And so we had to proceed. We had no choice.
But didn't that put you on notice that there was 3 days lost here and the court was operating under shortening time? And so why, again, my question is what happened to those 3 days and why are we 3 days behind our 10-day schedule?
I think that is the answer to that question, yeah, that's part of the problem with the statutory scheme as it existed then. But again, that is a burden on the moving party to be sure that all of the mandatory time limits of the statute can be complied with, including allowing the petitioner in this case 10 days to file opposing papers. When we go to the ex parte, we say, we're entitled to 10 days, Your Honor. Well, I can't give you 10 days, but we're entitled to 10 days. We need 10 days.
Is there anywhere in the record where we can find that objection?
Your Honor, that objection was submitted in declaration. It was not considered by the district court, but those documents are with the court. In addition, the declaration by the
Could
respondent.
you give me that again?
Excuse me?
Could you give me that again, the procedural posture? You are saying you made an objection.
We made an objection.
It is not reflected in the record from the trial court?
There was no court reporter. It was an ex parte. So the discussion in chambers were submitted to the Court of Appeal by way of declaration.
Okay.
One from the respondent, one from the petitioner. And so that.
And both declarations agree that that objection was made?
Well, in essence, what the respondent says.
That could be, the devil could be in that detail.
It could, because what the respondent says is that that Sharp, I want to be clear here, agreed to the extension, although begrudgingly, I believe is the way that he phrased it in his declaration.
Well, agreement is agreement, whether it's begrudging or not.
Well, but you state your objection to the court. The court says that I'm going to do it a certain way, and you have to move on. I mean, there's not much else
you
to do.
can preserve your objection.
We made our objection. There was no court reporter there, and that would be the only way to preserve it in that instance because this was an ex parte hearing. And that's the way that went. But to even get to waiver.
Well, I suppose that this would be a niggling little point, except all of the points being made are niggling little points. If I understand your position, you are saying that you are entitled to the relief you seek here because of a small procedural abnormality, and yet you would you sounded like you were acknowledging that there might be a small procedural abnormality on your side as well.
But-
Am I missing something?
I don't believe that you are, Your Honor. We did not have a court reporter there to preserve that record. I can
So
only.
can I ask you about that?
Sure.
You repeat that, and I certainly understand that.
Mm-hmm.
But what I don't understand is, would you normally have one there? Could you have had one there? You just chose not to pay for one that day to be there?
Well, because we used to have court reporters in the court at all times, and now we would have had to make that decision to bring one with us.
You
at
couldn't
that
have
time.
asked the court
We
to
did
have
not.
the minutes reflect your objection and noted?
I don't believe that did occur.
I beg your pardon?
I do not believe that occurred, that we insisted.
Well, I know it didn't occur,
Right.
but your position is, well, we didn't preserve our appeal because, or we didn't preserve our right to, we didn't preserve our objection because, for whatever reason, there was no court report. Well, that's not the only way you can preserve an objection, is it?
No, it is not. There could have been other ways to preserve the objection, Your Honor.
Thank you.
That is absolutely true.
You'll have 3 minutes for rebuttal if you care to.
Thank you.
Good morning. John Williams on behalf of the respondent. I'd like to speak directly about this chronology because it seems to be important to the court with respect to what happened when and what the various remedies may be based upon how that chronology unfolded. This was an issue that the Court of Appeal decided it didn't need to decide to rule in my client's favor. That is, whether the affidavits were timely filed on April 2nd, 2013, and then at some subsequent point were unfiled by the Superior Court when the court realized a few days later that a corresponding filing fee hadn't been transmitted with those documents. We don't want to concede the point that the court can unfile a document that's already been filed. And again, the Court of Appeal said, we don't need to look at that because we don't find that these are jurisdictional deadlines. But that's what happened here. And when we talk about this ex parte hearing that happened in the interim period between April 2nd, when these documents were originally filed, and notably served on opposing counsel, so they had them and were notified of what the arguments were and what the support was for those arguments. This ex parte hearing occurs on the 3rd. Now, I differ with my colleague with respect to the preservation of a record of objection to the setting of the timelines for the opposition. And so did the Court of Appeal. The Court of Appeal rejected the efforts of the appellant in this case to supplement the record by way of declaration and specifically said, we're not going to look at that. That's outside the record. You had the opportunity to preserve your objection, and you didn't do that. And so this argument with respect to the 7 days and how that ties in with the larger 30-day aggregate period just is not supported by the record that's before this court because the Court of Appeal said it was outside of the record and it did not accept those supplementary declarations. I also take issue with this idea that the trial court was in a bind, that it needed to compress the time for the other party to oppose the motion because of the 60-day time limit. Let's recall that the notice of intent was filed on March 1, 2013. 60 days from March 1 is April 30. The trial court heard the motion on April 12. It had a full 18 days between the time it heard the motion and the time that 60-day jurisdictional window would have shut. So the argument here being that the time was compressed for the opposition because there wasn't enough time to satisfy this 60-day jurisdictional window, and therefore the court was in a statutory pickle, I don't think is correct. It's not consistent with the chronology here.
Okay, these are all very helpful points. Could I ask you about the statute? Can you give us your comparison of 659 and 659A? That seems
Yes.
to be your opponent's strongest statutory argument.
I think what we see in 659 and what we see in 650 as well, 660 rather, is this idea that that the legislature wants the courts to consider new trial motions on an expedited basis. They want to make sure that they're timely filed, and that's what 659 says. It says these have to be filed within 15 days, and you can't stipulate for a period beyond that. The court can't order a period beyond that. That's an absolute jurisdictional deadline. And we know from well-settled case law that that is a jurisdictional deadline. I don't think anybody's disputing that here. So 659 embodies that policy that these motions have to be brought quickly. And then in 660, we have this consistent notion that the motions have to be determined quickly because a lot hangs in the balance. The time for appeal is told while these motions go forward if they're timely filed. And so that time is parallel. It requires the trial courts to do what? To scramble their flight pattern and really make available hearing time for these motions to go forward. Now, notable in both 659 and 660 are the penalties for what occurs if you don't comply. 659 makes it clear that the court lacks jurisdiction to decide these motions beyond the 15-day period. And 660 does so as well. 660 says that the motion is void as a matter of law if it's not decided within the 60-day period.
Can you point to the language in 659 that you refer to as penalty?
The fact that it cannot be stipulated to or extended beyond the 15-day period, that it's an absolute deadline. So that's my inference from that language.
That's an inference, but I mean your opponent says that this is just simply a shall statement. No, it's a shall not statement. Shall not be extended by order or stipulation. But it doesn't say anything beyond that, right? I mean that is all that it says.
True, that's what the language of the statute says, and I think the courts have been consistent, though, that to carry out the legislative intent that these motions be heard on a timely basis and pursued on a timely basis, that's jurisdictional. It doesn't say that specifically in the statute, though, Your Honor. I agree with that. 660 is clear on that issue, and it says that the motion would be denied. But I think this court was very clear, too, in the People v. Laura case, which we both have cited to, that the words shall and must aren't always indications of what the repercussions may be if those deadlines are not satisfied.
So is there not a symmetry between the 659's term shall not be extended, and then the phrase in 659A, not exceeding 20 days?
I think that you could make the argument that both are putting time limits on the parties, but there's a different implication in terms of what happens if those time limits are not adhered to. And again, my argument would be that the main focus that the legislature has in the statutory scheme is making sure these motions are pursued in a timely basis and that they're decided on a timely basis. If there is an issue with the interim briefing deadlines, then those are questions that are addressed to the trial court in the first instance and potentially could result in a ruling that, or in a allowance of a document to be filed that goes beyond what the statute allows. But
I guess that's the exact point in question in this case. And
correct.
I sort of feel like you've stated the position but haven't offered the argument for it, in the sense that the opposing argument here is that no one disagrees with everyone. I guess everyone's in agreement that on the front end and the back end, everybody agrees that these are time limits that cannot be altered. The court doesn't have power to alter them. So in order, the argument goes, because the legislature is so concerned about the front end and the back end, it's also concerned about what happens in the middle. And so the orderly development of the case in the middle must also adhere rigorously to these time limitations, or else the process is frustrated and the orderly resolution, the swift and orderly resolution of these new trial motions won't occur. So why is there this flexibility in the middle when the legislature, everyone agrees, is so concerned about the front end and the back end?
I understand your point, Your Honor. I guess I would differ with the idea that there's flexibility. I think all of the deadlines that are imposed in 659, 659A, and 660 all move towards the same goal, and that is to get these motions heard and decided. The question is, what happens if those deadlines aren't adhered to? And with respect to 659A, the situation is different, certainly than 660. We know that. Relative to 659, that's how the law has developed and said that's a jurisdictional question. What hasn't been decided is what happens with the deadlines with 659A. The Court of Appeal looked at this and said, look, those are deadlines that need to be adhered to, obviously. But if they are not adhered to, then those are deadlines that the other party has to object to or may be waived.
May I ask you about the objection, going back to what opposing counsel said? How could they object when they got notice that these papers were timely filed? They never got notice that that filing was eliminated, revoked, abrogated. So they never had an opportunity to object that they were not timely filed, that they were filed late, not within the 10 days. How can, I don't know if it was your burden to let them know, but how can they object if they don't know?
It's a fair question. I was not trial counsel, but I can tell you this. The burden to police adherence to these deadlines should be in these situations when they're non-jurisdictional.
Which you're assuming it's non-jurisdictional. That's what we have to decide.
With the parties and their counsel. And so in this situation, if you look at it and say, look, if it's jurisdictional, we're going to put it on the court to do it sua sponte. Or if it's not jurisdictional, we're going to put it on the parties.
Yes, but how can the parties do it if they don't have notice? As far as they knew, everything was in order and timely filed. And then, as the chief pointed out, they arrive and find that instead of 10 days, they only have 7 days to respond, if I have that correct. But how can they object to something that they don't know about?
I want to address your point, but I also want to make sure that we understand that the 7-day issue is separate from the actual filing of these documents, because they were served with these documents originally. The 7-day period occurred in an ex parte hearing, a subsequent ex parte hearing, and as I said, there was no registered objection on the record to that 7-day period. But taking your question, I suppose the answer is that the party should look at the register of actions, that they should take positive actions to make sure that these deadlines are adhered to so they can raise some sort of objection.
But they thought they were. They had every reason to believe that they were.
Well, if the alternative is to put the burden on the parties versus put the burden on the court, the better option is to put it on the parties here to register that objection. Why? So this issue can be brought to the court.
How about putting it on the burden on the party who knows that the filing was rejected and it's now going to be late?
I think that's a fair comment. Here it was not brought forward, and to the extent that it wasn't, I think it was viewed as a very technical problem with a filing fee as opposed to a document that wasn't timely filed. It was the position of Cabran's trial counsel that they did make a timely filing on April 2nd, and that this file stamp canceled and then a refiling date at some other point was not within the court's authority to do.
So in this case, actually, opposing party had actual notice. So we're talking about the technicality of whether that timely notice then became untimely.
The filing party had the belief that they made the timely filing on the 2nd. They were notified by the court on the 4th, I believe it was, through their attorney service, that subsequent to this being filed, and by the way, they were notified that it was filed on the 2nd. Their attorney service told them that, so they knew they made a timely filing. Then they got notification at some point later that it was stamp canceled and that a filing fee needed to be transmitted, which is what the attorney service transmitted at that time. and then that it was quote-unquote refiled at some later time. So from their standpoint, the original filing was valid on April 2nd, and that what had happened here was just a ministerial issue with respect
And the
to...
hospital had notice in a timely way, am I correct?
The hospital did not have notice of that issue at that time.
Notice of the April 2nd filing.
They received the documents on the 2nd. They were personally served on the
Okay.
same day they were filed.
So I just want to clarify that you're saying that notwithstanding the questionable filing and canceling, on April 2nd, the declarations of the two doctors, which was the basis for the new evidence for the new trial motion, the Sharp, the hospital, had possession of those documents.
Correct. And that is why we also raised the argument that there's no prejudice here. That this argument about jurisdiction was reverse engineered in some way because this occurs after the trial court rules, and they are then looking for a grounds for appeal, knowing that they did not preserve an objection or raise an objection, and that they had to find a purely jurisdictional issue to then be able to raise the first time at the Court of Appeal.
So your point is, in essence, that if the other side believed that the documents were actually properly filed on the 2nd and nothing altered their belief thereafter, they had all the time that they were entitled to.
Correct. They weren't prejudiced at all.
Okay.
And
So-
I'm sorry, go ahead.
No, please, go ahead.
Well, and that's what the Court of Appeal found as well. I mean, the Court of Appeal looked at this chronology and said there was nothing about what happened with the clerk. Again, we don't concede the point that the clerk can do this, but with the clerk accepting something as being filed and then later, without notice to anybody else, saying it's unfiled.
Right.
And that didn't affect them
Let me
anyway.
ask you then, this somewhat mysterious April 3rd ex parte hearing, what was the issue there then? What are the parties disagreeing about with respect to what happened at the April 3rd hearing?
My understanding was the April 3rd was to set the hearing date for the motion.
Your point was that the hearing date was set at April 12th.
Correct.
And the opposition was due April 10th. But the outer edge of this 60-day period would have been April 30th.
Correct.
So the trial court, why was the trial? So the trial court was proceeding earlier, in a sense, or giving itself some flexibility in case it needed to take up additional issues beyond the hearing. And at that point, Sharp was agreeable or disagreeable to this schedule?
Well, we have a difference of opinion there between trial counsel. I wasn't there, but the argument that's been made was that they disagreed, that they objected to this. The declarations of Cabran's trial counsel were that they consented to it. And ultimately, they never raised in their opposition papers that they filed any issue of timeliness, that they didn't have enough time, that they were cut short, that they only had 7 days, nor did they ever raise it at oral argument on the motion. So there's a disagreement about whether that objection was made at all, but there is no disagreement that it was not preserved.
May I ask you this? I think we have to decide whether that 10-day period of filing the affidavits is jurisdictional. If we were to determine that it's jurisdictional, we then would have to look to whether the clerk's unfiling it was a valid thing for the clerk to do. Would you say the Court of Appeal finessed that?
I raised the point for that issue because if we are making a determination that some act has jurisdictional import, the filing of a document by a date certain, and then the subsequent unfiling of a document by a clerk without notice, I think that's important for the court's analysis. And I know of no authority that allows a clerk to unfile a document that's already been filed.
But if we were to determine that that 10-day period, unlike other parts of the statutory scheme, is not jurisdictional and the parties can waive it, then we don't have to go to the validity of what the clerk did in the unfiling and refiling.
I think that's correct. I think that's what the Court of Appeal did in this case. It just said we don't need to reach that issue because we find that these are deadlines. They're mandatory, but the penalty for not satisfying them is not a jurisdictional penalty. And I do want to touch on the difference between the two because I think this is important for the court to understand. Again, the idea of a mandatory deadline doesn't mean that it can be avoided at somebody's whim. It needs to be met. But it's policed by the parties and can be waived if it's not asserted. And the policy behind a mandatory deadline, again, it's still a deadline, but the idea of putting the burden on the parties rather than the court is that it promotes efficiency and finality by requiring the intervention of the courts only where the parties object.
All right, so in this case, let's go back to the part, let's assume for purposes of argument that we think it's something that is not jurisdictional, the parties have to object. In your view, when could these parties who had no notice of the alleged late filing, when could they have objected? Am I not clear?
No, I understand your question. I'm pondering my response. I think that in this situation, again, the burden, it's a question.
Let's say it's their burden.
Yes.
How could they have met that burden?
Again, I think that if you're talking about deadlines here, you need to monitor the register of actions. You need to make sure that these documents are filed at the right time.
So it's really just too bad because they thought they were timely filed and they only belatedly, after the fact, discovered they weren't.
Well, I think it's more no harm, no foul because they were timely served.
You're resting, in a sense, on the quirk of this case, which is not necessarily how late filings would ordinarily occur. You had a timely filing,
Correct.
which was then unfiled, and the late filing then occurred 3 days after. That's a different scenario than if the late filing had just simply occurred late, with no original timely filing that, as the parties don't dispute, did give notice to the non-moving party here. So that's the no harm, no foul concept, is that they did have notice at the earlier date, and so it's only an after-discovered fact that the lateness. But that's not how lateness would ordinarily arise, or I don't know what's ordinary, but in a different scenario, if it was just late, that would the party would be alert to the fact that it was late because that's the first time they would have encountered the document, and they should calculate on the calendar, oh, we're getting it on April 5th instead of April 2nd, and that's late.
And I think that distinguishes this case from Erickson, where the Gonzalez affidavit was clearly late. It wasn't filed and then unfiled at some later time. That, to me, is a big distinction here. And I also want the court to appreciate that with the recent change of the statute, we were operating under the old statute, but with the recent change of the statute, not only have the briefing intervals been changed, but there's an opportunity for a reply now that never existed before under the statute. And so if there are issues of timeliness going forward, if something is filed late, the parties will have even a further opportunity in opposition and on reply to address that to the court to develop a record on the question of timeliness. So a reviewing court can look at that and say, well, we think you acted outside of the time limits, or you waived that issue. So from a prospective standpoint, I know we're applying a statute that is no longer active. A lot of these issues may be ameliorated with the additional briefing and the ability to file a reply to deal with these issues at the trial court level. I have to say this, too. I don't think it's beyond anybody's common experience that agreeable parties may stipulate to briefing deadlines on post-trial motions as the case dictates. There may be cross motions for JNOV and new trial that are brought, and it may be that the parties agree on time intervals that make sense with them, and then the court gives its imprimatur and says, I'm fine with those briefing deadlines as long as I get the papers by this date before the hearing that is scheduled on this date. And there is nothing that should prevent that from occurring if these deadlines are mandatory, but if the parties make a stipulation, then they waive that mandatory provision. That, again, promotes efficiency.
But if it's jurisdictional, they can't.
If it's jurisdictional, they can't do that. But again, we want to encourage parties to do those sorts of things with the trial court's approval. I've done it a ton of times, and I've seen it in practice as well, that if that's what the parties want to do, they shouldn't be restrained from doing that, especially if the trial court is agreeable and it works with the trial court's calendar. Now, on the other side, if this is a jurisdictional issue, and I talked about the benefits of what I call a mandatory rule that is not jurisdictional, if it's jurisdictional, you're going to put the burden on the courts to police these issues sua sponte. And if anybody's been through the experience of briefing post-trial motions, they know that you've just gone through a trial, you've gotten to verdict, and got a judgment that's been entered, and you're working under very tight time deadlines. The courts have to scramble just to get the hearing on calendar within the 60 days because most of their dockets are clogged with other law and motion matters that are set well beyond that. And so to that extent, you'd be putting a tremendous burden on the trial courts to police this sua sponte as opposed to asking the parties to bring this issue to the court's attention, allow it to be briefed, allow a full record to be developed on this issue, and then a ruling made that can be reviewed by the Court of Appeal here, as opposed to a situation where we don't have an adequate record of objections that are being made on those issues. And again, I would submit that the likelihood of a timeliness issue being more fully briefed under the new statute is higher because of the allowance for a reply brief. So if this is raised on opposition, there'll be some response by the moving party, and then the trial court can make a ruling on a fully developed record. The final thing I'd like to say about Erickson, and I know I said this in my briefing, but I think that it's important to understand that the trial court in Erickson considered the late filed affidavit, the Gonzalez affidavit, and still denied new trial. And so when the Court of Appeal was looking at this issue, all of the language in the Erickson case talking about the jurisdictional nature of that filing deadline was really dicta at that point, because at that point, how could Dr. Weiner be prejudiced by the trial court's consideration of an affidavit when the trial court still ruled against him? So Erickson went down a road that it didn't need to go down. And I think the Court of Appeal recognized that, and that was inconsistent with other authorities up to that point, certainly inconsistent with how Professor Witkin has written about that issue in the past, and therefore doesn't provide a good analytical path for this court to follow in deciding this case. Unless there are any further questions, I'll submit.
Thank you, Mr. Williams.
Thank you.
Your Honors, I'd first just like to point out that it was well briefed in the Court of Appeal, the mandatory nature of the filing fee being required for the acceptance of the papers. It's been determined that a filing fee is a condition precedent for filing of the motion, and that's Duran v. St. Luke's Hospital. In addition, cited in the brief were the Court of Kientz v. Harris, which dealt with filing a motion for a new trial without an accompanying filing fee, was properly rejected by the court. So I don't believe that that is really an issue here before this court. That the law is very quite clear on the clerk's authority to reject the papers. I would also point out, Erickson did not...
Does it make any kind of difference that in this case, let's assume that you are completely right, that the clerk can say no filing fee, no filing. Here, the clerk kind of engaged in a nunc-pro-tunc action, doing later what it could have done at the outset. And part of that is what has created all the dust in the air today, right?
That's right, Your Honor, but I think the issue here is we don't really have to get to that waiver issue, because our determination here is that if any consideration of papers that were untimely filed should be treated as void. And it goes back to the basic issue of how we're going to interpret the jurisdictional nature of 659A. And again, in comparing that to the language of 659, and a good thing to point out here, Erickson is not the outlier here. It follows every single case, with only the exception of the Clements case, which was very narrowly construed, that when we're dealing with the aggregate limits of 659A, that it is void if not followed. And this idea in Witkin that this is the outlier is not true. The cases cited in Witkin and the cases cited by the respondent only deal with the 10-day limit of that statute, which clearly is not jurisdictional in the face of the statute because it gives an exception to that.
Does the record shed any light on who got notice of what when the clerk took the action that it did? In other words, did the clerk notify the court, or did the clerk go to the court and say, "Can I do this, nunc-pro-tunc"?
It's a very good question. What the record reflects only that there was no service after the second on any party. Number two, it reflects that the court entered the rejection on the 4th and that it accepted the new filed papers on the 5th. But it doesn't indicate anything about giving notice, with the exception of the fact that there were declarations filed by the counsel for the respondent that indicated that the clerk notified them on the 4th that the papers were rejected and considered unfiled and that they needed to refile them. So that's when they had notice of the fact that their papers had been rejected. And that is the only party with that notice, and we would again contend
So they got notice on the 4th?
They got notice on the 4th.
And they refiled on the 5th?
And they refiled on the 5th, the appropriate papers.
It's almost just Keynesian circumstance.
It is a very odd circumstance, but again...
Well, it's beyond odd.
Yes, it is, Your Honor. But I would just say that in a general sense, in closing on this, that there's a danger in saying that this is a directionary statute in the center of these two jurisdictional bookends, because it gives too much of a sliding scale for the court to really affect the prejudice of the parties by picking and choosing when the affidavits are due, even under the new statutory scheme. If it's not viewed as being jurisdictional, as the legislature has indicated in their history, as was put in the briefs, then the new statutory scheme has no meaning because the court is not required to follow it.
Thank you, Mr. Doggett.
Thank you.
Mr. Williams, the matter is submitted.
Thank you.
Good morning, Your Honors. May it please the Court. Section 261 defines different offenses. In Gonzalez, this Court held that the identical oral copulation provisions define different offenses, and applying that same test here yields the exact same result. People v. Craig has been read to say otherwise, but the Court in Craig was looking to former Section 261 for a legislative intent to define multiple punishable offenses. Today, this Court's inquiry is different. It's whether the legislature intended to define different offenses without a concern for the legislature's intent regarding punishment.
What is it in Craig that leads you to think that the court was concerned about multiple punishment?
The language of Craig itself, and the Court on several occasions references that it is concerned with whether or not 261 defines multiple punishable offenses. I will agree that there is some additional language in Craig that has been read more broadly, and as 261 defines one offense committed under different circumstances. But I think given the context of Craig as a whole, it's clear that what what the Court was looking for was the legislative intent to define multiple punishable offenses.
Did this interpretation of 261 originate with Craig? Weren't there cases earlier, such as the Snyder case, the Vann case, that had taken a very similar view of the rape offense?
Yes, there were.
Were
similar
those cases also motivated, in your view, by a concern about multiple punishment?
No, those cases were motivated by a concern about pleading requirements, and they were also decided under prior versions of Section 954, which provided for different, allowed for different charging. So you could, for a while, only charge one offense under 954, although you could charge different statements of the same offense. 954 has over time been broadened to allow lots of different charging options. Craig is the first case, I think, that's concerned with the number of convictions that can result. So Snyder, Vann, and Jales all concern what can be pled and what can be proved at trial. Craig is the first case that concerns the number of convictions that can result. But given the historical context of Craig, it's understandable that the two questions, does Section 261 define multiple offenses and are they multiple punishable offenses? Those two questions were conflated in Craig.
How do you deal with the fact that in the Gonzalez case, we distinguished Craig?
I think this court appropriately distinguished Craig in Gonzalez because Gonzalez does deal with a different statute.
But in so doing, did we not imply that Craig was viable and continued to be valid or not?
No, I don't read Gonzalez as continuing the vitality of Craig. I think instead what this court did in Gonzalez was note that specifically with respect to each given statute, there's a separate question of legislative intent. And each statute must be evaluated on its own merits.
Well, the considerations that we spoke to in Gonzalez with respect to separate offenses, how do they pertain to 261?
I think the analysis in Gonzalez lifts almost exactly out of 288A, and when applied to Section 261, it yields exactly the same result. The first question in Gonzalez, the elements of the offenses. And this court said most recently in Vidania that, in fact, that is the best indicator of legislative intent.
But each subdivision was self-contained and had separate punishments. And do we see that in 261?
No, not to the same extent. But this court's analysis in Gonzalez, I think the important part is that the starting point is the elements of the offense. That is, in fact, the primary means by which the legislature defines criminal conduct.
By that, do you mean the application of the Blockberger test?
I think Blockberger is perhaps best described as an exclusive elements test. And what this court said in Gonzalez and in Vidania is that California has not adopted necessarily an exclusive elements test. And that's best demonstrated by murder and theft, two types of crimes which involve different elements, but the fact that they include different elements for different types of murder or different types of theft is not dispositive of the legislative intent. So to get back to Your Honor's question, the fact of self-containment, which is a structural element of 288A and not a structural element of 261, is a supporting factor. It is another thing that this court can look to support a determination regarding legislative intent. But it, too, is not dispositive, the same way that elements are not dispositive. So I think the test, as this court has said, is more of a totality of the circumstances test. But again, the primary indicator of legislative intent would be the elements. And what Vidania explains...
Well, once you get to totality of the circumstances, I mean, it then becomes, given, if you don't think that these textual features are dispositive, then I suppose it is additionally probative that the legislature, despite revisiting these statutes over and over again, never saw fit to change the language of 261 in any fundamental way, despite the fact that Craig has been on the books and in Gonzalez. I don't think it's quite right to say that we didn't tip our hand about Craig in Gonzalez. We said, this is the language of Gonzalez. This conclusion, namely Craig, flowed naturally from the wording and structure of former Section 261.
I think Craig, when it's understood that the court was looking for a legislative intent to define different punishable offenses, it clarifies why the legislature has not revisited Craig, because there is no intent in Section 261 to define multiple punishable offenses. And in fact, Craig's holding that 261 defines only one punishable offense is not only consistent with the legislative intent behind 261 at the time, it's consistent with the legislative intent behind 261 now. So there would be no reason for the legislature to go back and say, you know what, Craig got it wrong.
Well, let's even grant you that point, that this word punishable in Craig bears the weight that you put on it, which is an awful lot, I must say. But because there was available to the court, even at the time of Craig, the option of concurrent sentencing. It's not that in practical effect, the question of multiple punishment could not have been dealt with otherwise. But even assuming you are right, that the word punishable has this weight, it nonetheless is the law of Craig that it defines one offense. Not one punishable offense, but one offense. That is the law of Craig. And the legislature has never revisited that holding.
Yes, I want to address one.
Even though we now have 654 and all these other things, I mean, if the legislature had thought that 654 took care of the problem that you say Craig was trying to address, then presumably it would have seen fit to tell us that. Instead of leaving it to tea leaf implication that somehow the legislature has now disagreed with Craig.
Just with respect to the weight of the import of punishable offenses, the sentences in Craig were run concurrently. So the court knew and was aware that concurrent sentences were available to it because that's in fact what the issue was before the court. These were not consecutive sentences. The problem was that Craig in 1941 was decided under indeterminate sentencing. So a defendant like Craig would be sentenced to 50 years to life, no more than 50 years on the rape convictions, and then the parole board would determine his release date. And there was a concern, even with concurrent sentences, that because there were two convictions, that could work a disadvantage to defendants in terms of the release date that was going to be set by the parole board at some point in the future. So that was the concern before Craig, was that even though the sentences before it were concurrent, that it could work a very real disadvantage in terms of the punishment that was ultimately suffered by the defendant.
So this answer to Justice Liu's question and your previous answers highlight why you think we can draw a distinction vis-a-vis Craig. But if, for a moment, assuming we don't buy that, you want us to overrule Craig?
I do. I think...
Why is the unique action of overruling the case appropriate here?
The unique action of overruling the case is appropriate here because to hold otherwise puts the rape statute, it directly, I think, violates the legislative intent with respect to the rape statute. And that's most clearly seen through three things: the text of the statute itself, the statutory scheme, and the legislative intent to treat the four major sex offenses similarly. A finding that Craig is viable and means that 261 defines one offense would put rape into its own category, and oral copulation, sodomy, and sexual penetration into another category. Notably, 289, which is sexual penetration, is designed exactly like 288A and does have that element of self-containment. So this court would be forced to draw the distinction that those three offenses define different types of sexual assault offenses, but with respect to the rape statute, it's only one.
Can you shed some light for me on the practical implications of treating rape differently from the other major sex offenses? And in particular, I mean, it seems to me that the implication of the position you're taking is that in cases, I would assume, and please correct me if I'm wrong, that this would arise typically in maybe date rape sort of scenarios where there might be some question about whether or not this is rape of an intoxicated person or rape of an unconscious person. And the consequence of your position would be, I assume, that the prosecution would need to prove to a jury unanimously one version of the offense rather than the other, rather than having some jurors believe that the victim was intoxicated and others believe that the victim was unconscious.
So our position is that because these are different offenses, they do have to be charged separately and proved unanimously to a jury, which was done here, and which is typically how these cases are charged and proven below. I think to find that this is one offense necessitates essentially the way the legislature defines crimes. You have two buckets. In one bucket, you have crimes like murder and theft, which are alternative means of committing one offense. And traditionally, when you have an alternative mean of committing an offense, unanimity is not required. You can charge a bare murder count or a bare theft count, proceed on different theories, and instruct the jury that they need not be unanimous with respect to the means.
And so I guess the question is, why are you taking a position on behalf of your client that you can't treat rape in the same way?
I think because there's no authority to support that. In general, with murder, there's a long history of treating murder as different means of committing the one offense. Theft, as this court explained in Vidania, sort of became one offense for which unanimity was not required with the 1927 amendments.
But so too here, don't we have a long history of, since at least Craig, if not before, of also treating rape as a unitary offense?
We don't have the same clear history. In particular, Collins determined that charging one type of rape and proceeding on a different type violated due process. So prosecutors and trial courts would not permit one charge of rape to go forward. I should say the extent of the case law is a little bit limited in that no court has decided that you can or cannot charge one bare rape count and proceed on different theories. But Collins does say you can't charge one subdivision and proceed on a different subdivision.
History can be pretty important, counsel, and certainly weighs on this kind of case. But leaving history aside for a moment, what's your pithy statement of what the biggest analytical difference is between rape and theft and murder with respect to whether they're unitary offenses or not?
I'm not sure I understand. The biggest...
So why is rape different from theft and murder?
Well, I think in either case, whether we're talking about alternative means of committing an offense or different independent elements, it comes down to legislative intent. The legislature can choose to do either. But in this case, there's no indication that they've chosen to sort of put rape into the bucket with murder and theft in terms of allowing a bare rape charge and proceeding on different theories. The other notable distinction between the rape statute and the murder and theft statute is that a bare charge of 261 doesn't necessarily charge a crime. 261 subdivision A defines the act, which is at issue in rape cases, which is the act of sexual intercourse. You could be in violation of section 261A without ever committing a crime. You have to add the subdivision.
No, that doesn't track. You can't be in violation of a statute, a criminal statute, without committing a crime. You can commit an act that is contemplated by the offense or by the definition, but not be guilty of a crime because you lack mens rea or you lack notice or you lack lots of other things. But I don't think you can say you can commit a violation of 261A and not commit a crime.
Perhaps describing that way is not the most accurate. I think the point is you could a bare charge of section 261 does not necessarily indicate criminal activity the same way that a bare charge of 187 does or a bare charge of 484 does.
And I think you need to explain why that's so.
So in 261, subdivision A defines that the act at issue is an act of sexual intercourse, but it does not make all acts of sexual intercourse criminal. The act of sexual...
I think we can all agree on that.
The act of sexual intercourse only becomes criminal if it is committed under one of the subparagraphs that follow subdivision A. So
but
if
isn't that the same as with murder? Not every act of homicide is criminal.
But section 187 does say an unlawful act of homicide.
So that's why it does say that. So that's why the two are different. In other words, the language of the statute treats the analysis of actus reus and mens rea differently by virtue of its language.
Yes. And I think that's the indicator from the legislature that what they intended with 261 was in fact to define different offenses and not to define one crime which can be committed by various means.
Can I ask you, I don't think your position is unreasonable. I mean, this is a tough statute to interpret, and we got these surrounding statutes, and then we have all these cases, right? So it's a big mix of things. I'll tell you what bothers me. Craig is a statutory construction case. That is the zone in which stare decisis has greatest force, because it's a statute, and if the legislature disagrees with us, they can change it. This is not an area that's mysterious to the legislature. They revisit this, it seems, all the time. There's lots of, including 261 itself, there's been lots of amendments, and they know about Craig, it's been on the books. Even if you were correct, right, that Craig was based on a reasoning that has now been rendered obsolete, and even if you were correct that we should overrule Craig, does that require us then to further, and I mean, that's a big concession in the sense that Craig is entitled to the full weight of stare decisis, right? But if we overrule Craig on the ground you suggest, don't we have to effectively at least rewrite Gonzalez? Because we would have to repudiate these statements from Gonzalez. The one I read you, this conclusion, Craig, flowed naturally from the wording and structure of former 261. And then we further said 288A, the oral copulation statute issued in Gonzalez, is textually and structurally different from former 261. These were the grounds of our decision in Gonzalez. So you would ask us to overrule Craig and then effectively overrule the rationale of Gonzalez too. That is a lot of overruling to do in a statutory construction case, in a place where the legislature has not been oblivious to what the law is.
I don't think by any stretch of our position we're asking this court to overrule Gonzalez.
Well, what about the reasoning of Gonzalez? This is the core of the reasoning in Gonzalez, that Craig is not applicable, because that was what that case was about, is whether Craig should govern 288A as well. And we rejected it, distinguished it, on the ground that Craig, the decision flowed naturally from the wording and structure of 261.
I think what this court noted in Gonzalez, which was important, is that was true with respect to former Section 261.
Okay.
And the statute has been changed substantially since then. Now,
are you resting on those distinctions, though? The changing of the word either to any and the semicolons replaced by periods?
No.
I mean, what changes?
But aren't you referring to the specific addition of under the influence and unconscious to the 261?
those two types of rape offenses existed at the time of Craig as well, but there have been other substantive changes to 261.
Wasn't the rape of a minor separated out?
It was.
Later? And that was what the court was talking about in Craig?
Yes. In fact, the two crimes at issue in Craig, unlawful intercourse with a minor, which at the time was called rape of a minor, and forcible rape. And I would agree that in 1970, when the legislature recast rape of a minor and turned it into unlawful intercourse with a minor, they did not do that with an explicit intent to overrule Craig. I don't think that's a fair reading of the legislative history. But the import of that move is telling. And to the extent that Craig said rape of a minor and forcible rape are the same crime, the legislature very clearly in 1970 said rape of a minor and forcible rape are not the same crime.
Doesn't that exactly undermine your position, which is that when the legislature knew that it needed to create a separate offense, it did so. But the fundamental reasoning of Craig that put all the other rape circumstance offenses into one statute, 261, was not disturbed by the legislature.
I think had the legislature taken that action with an explicit intent to overrule Craig, there might be this import that the remaining provisions should stay under the ruling of Craig and should remain the same offense. But that's not why they made the move they made. They made the move they made for other separate concerns which had come to the legislature.
But your argument, though, is essentially that after if I follow, I just want to be clear, after 1970, given what the legislature did, the continued validity of Craig was a question mark. So you're not taking on the idea that stare decisis should be very strictly applied in the context of statutory interpretation. You're suggesting that there's a distinction in the statute that's significant enough that really we shouldn't simply mechanically apply Craig.
I agree, yes. And in fact, I think that the continued vitality of Craig It was earlier than 1970 that came into question. In Ex parte Hess, this court read Craig exactly the way we've indicated it should be read here, which was Craig was a multiple punishment case, and it was looking for a legislative intent to define multiple punishable offenses, not the legislative intent this court is looking for today.
How does Hess affect our analysis that came after Craig?
There is no analysis that came after Craig which undermines that. The only thing.
But doesn't Hess support your position?
Yes, and I think what Hess is helpful because this court has already read Craig in a limited way and read it in the historical context that was before the Craig court in 1941. So to the extent that this court needs to revisit Craig, I think it can also revisit Craig in light of the limitation that was put on Craig in Hess. And
so let's take a step back from this whole process. We have 288, and Gonzalez says that committing those crimes under the influence or unconscious victims are two offenses. We have 261, which refers to unconscious and under the influence victims. If we go the route by saying that 261, unconscious, under the influence victim, is a single offense, are we essentially saying that the legislature meant to treat rape victims more lightly, less outrageous than 288A victims?
I think, yes, in some senses, it would demonstrate a legislative intent to treat rape differently than the other major sex offenses, and importantly, to treat rape more leniently.
Not more leniently, because in answer to Justice Kruger's question, it would be easier for the prosecution to prove rape. You don't need unanimity among the jury among the circumstances.
I think assuming that if this court were to go that route to find one offense, there would need to be some clear guidance to prosecutors and trial courts below.
Why do you need two offenses? If one of them falls, I mean, you can't sentence for both of them, but if one of them falls, isn't that the reason you want the two offenses?
The two offenses are important for a number of reasons. One is, yes, an accurate factual representation of the record. The defendant in this case committed a rape of an unconscious victim. That was a fact determined beyond a reasonable doubt by the jury. The fact of the crime he committed should be reflected. In addition to that, for preservation of the appeal, I think it's important. But also, some of these rape offenses have different punishments. And we can't punish one crime under two different statutes and two different triads. There's no authority for how a trial court would go about doing that. I think importantly, in other contexts, 654 applies because one act has violated different provisions of law. But a finding that these are one offense would be a finding that one act violated the same provision of law. And
are there different penalties that attach to rape of an unconscious person and rape of an intoxicated person?
Not these two particular crimes, no. But there are different penalties that attach to forcible rape on a minor. There are, importantly, forcible rape and rape by threat of retaliation are considered violent crimes under 667.5. The other types of rape are not considered violent crimes. These are all indicators that the legislature does not consider these all to be the same thing. They've assigned different punishments to them, and they've indicated that certain types of these crimes are violent and other types are not. In that respect, these are different offenses, and charging and proving them as one offense presents some difficulties.
Well, if you were to charge and prove them as one offense, could some jurors find the defendant guilty under one of the circumstances and somebody else under the other circumstance and just be a general verdict of guilty?
I think, I'm sorry, I see that I've...
Yes, but you have 5 minutes of rebuttal if you care to use it.
Yes, I think the buckets that I mentioned, one, murder, theft, which does not require unanimity, and then there are everything else falls into the other bucket, which is that you have to charge different offenses, and those do require unanimity as to the different elements. Again, the reason murder and theft proceed on a lack of unanimous verdict is because there is strong and long authority that permits prosecutors and trial courts to proceed that way. I think if this court were going to conclude that this is one offense, it would need to provide similar guidance to prosecutors and trial courts that it can proceed on, that they can charge one rape offense, proceed on different theories, and that a unanimous verdict is not required.
But the problem with that is with an open count of rape, unlike an open count of murder, which may then charge enhancements that get you to first degree, is that at that point I envision arguments that the defendant wasn't on notice of the nature of the type of rape. So then we have potentially due process issues when you have an open count of rape, 5 different ways that you can rape a woman.
I agree that those are the issues that necessarily arise in the context of one bare charge of rape. In addition to that, because rape offenses have different punishments, you could wind up in a situation of not having a unanimous verdict on either theory, and the 2 theories carry different triads. And it's impossible for a trial court in that situation to know what punishment has been authorized because they have no way of knowing whether the jury was unanimous as to forcible.
Other than the example you gave, you said it very quickly. The rape by what was the comparison between the 2 punishments? Most of the punishments are in the nature of the age of the victim. Variation.
Forcible rape has different punishments that do differentiate based on the age of the victim.
But those are not at issue here in the sense that that's just an objective determination. That's a single piece of fact that would apply no matter what circumstance was alleged, to the extent that you're alleging the same victim is suffering 2 circumstances of rape.
I think the triad punishment does not change with respect to the age of the victim for other types of rape. So here, for instance, forcible rape on a child under the age of 14 is a 9/11/13 triad. That's not, the same does not apply to a child who was unconscious or a child who was intoxicated. I think those are still a 3-6-8. You may have other crimes, lewd acts on children, that kind of thing, which could also be charged. But in that sense, and in addition, this court has said time and time again that where it's the additional fact, which must be proven to the jury unanimously, and it results in a new triad, that's a new crime, as opposed to a penalty enhancement, which is just tacking on of an additional set of years. So forcible rape of a minor. In fact, one of the grant and hold cases behind this, which is People versus Macinas, involves the forcible rape of a developmentally disabled 15-year-old. And the defendant in that case was charged and convicted of rape of a developmentally disabled victim and forcible rape of a child who was 15. Those 2 crimes carry different triads, and obviously one was stayed pursuant to Section 654. But if this court were to conclude that it's only one offense, it's not clear how the trial court would decide what the appropriate punishment is. And so by assigning different punishments to the different types of the rape offenses, the legislature has given a very clear indication that these are not all to be considered the same offense. I'd like to reserve the 45 remaining seconds for
Well, you have 2 minutes for rebuttal by my clock.
Good morning. Raymond DiGiuseppe for Appellant Billy White. May it please the Court. The judgment in this case should be affirmed based upon the current status of the law of rape. This is evident for 3 essential reasons. Number 1, the indisputably unique textual and structural features of the rape statutes, reflecting a design of a unitary offense set apart both Penal Code Sections 261 and 262 from every other major sex offense statute and virtually every other sex offense in the Penal Code.
What about the question of punishment?
Well, punishment varies in the indication of minors. There are enhancements. They're not separately defined crimes. So
Well,
264
they're only,
provides.
I mean, you can think of them as enhancements if they relate only to a single factor like age. But where the circumstances of the charged offenses simply differ, and they differ as to the elements necessary to prove them, and then those differences carry different penal consequences.
Right.
What are we supposed to do?
I think that the different collateral consequences and the different direct consequences are matters that reduce to policy concerns at the end of the day, because we have that in other instances where the legislature has said We're not going to allow multiple profiles.
But we held in Gonzalez that 288 violation against a victim that is unconscious and a victim that is under the influence are two separate offenses. Why doesn't that apply to rape?
It doesn't apply to rape for a few reasons. Number one, there was no history of case law leading up to Gonzalez which would have established.
Is there any indication in the legislative history that the legislators wanted to treat rape different than oral copulation?
I believe so, with the differences in the textual and structural features of the statute, which make it appear very different from the others, which have been retained despite the repeated constructions of it as meaning a unitary offense.
Why would the legislators want to treat rapists more leniently?
I don't know the answer to that question. I don't think that's entirely the case, though. That's necessarily more lenient.
But can I ask you this question? Lenient or not, what would be the policy reason for the legislature to treat rape differently from oral copulation, different from sodomy, and different from sexual penetration by a foreign object? Why would those be different? I know the text is.
Right.
I know the textual composition is different, but as we try to discern this, and if that doesn't answer all of our questions, then we look to leg history and we look at Craig, but what's the policy reason that the legislature would consider treating rape differently from the other sexual crimes against unwilling, unconscious, intoxicated victims?
Yes, that's a good question. And I think that the first way to answer that is to remember that we've got these canons of construction which require that we apply certain presumptions because we don't know all those answers. So that's the first part of it. The second part of it as to why there might be an explanation of what we could maybe speculate about.
Before you go on, the canons of construction, how do you apply them in this context?
The canons of construction, I think, lead us to the point where we have to...
Well, which ones? I mean, just unpack them.
Well, the textual ones for one thing, but we're more specifically, I think, now focusing upon the canons that require the court to apply a certain presumption when the legislature has enacted statute in a particular way that
Well,
applies.
first of all, canons never require anything. Canons are guideposts for interpretation of the statute, and you can, like Shakespeare in the Bible, you can find a canon that leads you almost anywhere. So it's not, number one, it's not precisely accurate to say they require. Number two, I think what Justice Cuellar is asking is, even if they did require, which ones are you relying on? Which canon of construction compels the result under your analysis?
Are you talking about canons of construction, or are you talking about principles of stare decisis?
Well, that as well. I think that they're related to one another. But as far as the canons of construction go, I think textual and structural canons, which require us to read the language of the statute to begin with, we have indicators in here which have been left over time despite all of the examination, which suggest a singularity in the construction of the statute, like the reference to a singular act and the use of any of.
So I'm sorry to interrupt this,
Sure.
but I have to say, I think the constructual, the textual argument, I understand, but we still have to read it in a way that using canons of construction doesn't make it absurd. And I just don't, and I guess your answer, maybe I'm putting words in your mouth, but you didn't really answer that you have a policy why we would treat rape differently from the three major sex crimes.
Sure.
And so maybe what you're saying to me is you can't think of a policy because I can't either.
Well, I haven't gotten to that yet. I haven't quite gotten to be able to answer your question yet because of the intervening questions, which is fine.
Maybe now would be a good time to get to that.
Yeah. So I think we have to be careful not to allow the concerns over anomalous results to overwhelm or allow that to evolve into policymaking. But as far as policies goes, I investigated that as best I could. I think that Justice Werder's dissent in the Johnson case may have a clue as to this historical bias that might remain.
Okay, could you remind me of that?
Sure. The historical bias that might remain from a period of time in the past when people used to consider oral copulation to be essentially a crime against nature, very negative perception of that.
It would be hard to argue, however, that people took a less harsh view of the crime of rape. It may be that sexual mores have changed somewhat in terms of whether or not anybody in their right mind would engage in this behavior.
Right.
But I think you strain your argument to a certain extent to say that people really, really didn't like oral cop, but rape,
Well,
not
here's
so
the thing.
much.
The alternative view here, I think you could apply for purposes of policy, just cuts the other direction in that because rape is certainly considered, probably considered the worst type of sexual offense there is, it's probably the worst label to carry. So perhaps the legislature, we saw the legislature identified a specific concern when it moved the statutory rape over to 261.5 of the highly negative stigma of rape. It's not even called that anymore. That's a non-rape offense now. Perhaps it had to do with the legislature's belief that labeling of rape as the worst sex offense label you could probably give someone justified continuing this long history of this construction that obviously it was aware of in the judicial branch.
Well, that would be great if we were trying to deal with some interpretation of 261.5. But what we are challenged to do here is either harmonize all the other sex offenses with rape or articulate in some reasonable way why rape should be treated differently than all these other abhorrent sexual offenses. And I think you may have given us a reason, but if you did, I missed it.
Okay. Those are the only reasons that I could come up with on my own, because I think that's the reason why these, whether we call them plans of construction or other principles that allow us to help ferret through these discussions are important, because we don't get all the answers from the legislature as to these statutes when they're written.
Is there any imperative that the legislature have some sort of rational scheme behind all these sexual offense statutes?
Not necessarily.
I mean, the penal code is very thick in California. Is there any imperative that it have some rational scheme across all of these different crimes that it defines?
I don't think so.
Especially in an area where the legislature is not unaware of what these statutes say.
I think you're right, and I think that's why I pointed out in the brief that this isn't a search for a rational basis. This is a case where we're looking at principles of stare decisis, structuring of the statutes in a very unique way from the others.
Isn't it enough that the statute is not absurd to read it as it is? Whether or not it coheres with the other offenses is a separate matter, but there's no imperative that the legislature legislate rationally across all of these different crimes, as long as the crime it defines is not in some way infirm in and of itself.
Right. And I think that is true. And another important thing to keep in mind is that if we were to follow the rationale of, well, we need to now abandon this long history of construction of 261 as unitary offense and pick up this entirely unprecedented one that's presented by the Attorney General, where does it end? Doesn't that just open up the door to a slippery slope? Because then all future prohibitions against multiple convictions in sex offense cases could be considered subject to challenge for the same kinds of reasons, because we're not treating them the same as oral copulation.
It might feel differently if this were an equal protection claim brought by a defendant who claimed that jury unanimity with respect to the circumstances not being required under your reading of 261 seems to disadvantage that defendant relative to what a reading of 288A would be under Gonzalez. That would be a different case. That would be an equal protection case where we'd search for a rational basis. But the Attorney General is not pressing an equal protection claim before us. And so it seems odd for us to want to impose upon the legislature a requirement of rationality, which I'm not even sure what the doctrinal hook for that would be.
Yeah, I don't think that there is one, Justice Liu.
Can I ask you to respond to the Attorney General's argument that the consequence of this position would be unworkable because the consequence would be that jury unanimity wouldn't be required with respect to the intoxication circumstance versus the unconsciousness circumstance, and that would lead to due process problems, failure of adequate notice to defendants, and difficulties by trial courts attempting to impose proper sentences.
Mm-hmm. Sure. And I think that is in the context, I believe, where it would be considering all those to be different theories of one count of rape, right? Okay. That's one situation which may arise from it and can result in potential problems, I suppose, along those lines. I had suggested in the briefing that we treat them as alternate counts, because then you don't have that sort of due process issue with respect to notice. All we're left with are the concerns that are raised by the Attorney General concerning different collateral consequences of what could turn into two different offenses, but not if they're charged the right way and tried the right way and instructed the right way and argued the right way to the jury as alternative offenses that can only return one conviction.
If we go that route, I mean, if so the notion is that you have alternative charges, alternative counts in a information. What does that, in a sense, cause the prosecution to forfeit a general count? Do they have to elect at that time whether they're going to go down this route of requiring, in a sense, kind of special verdicts on the particular facts? And if the jury can't return special verdicts, do they still retain the option of getting a general verdict on rape?
Well, that's a good question. I don't think that it forces the prosecution to make an election. That's the whole idea. If you think about, for example, in the continuous sexual abuse context, 288.5 and then the discrete offenses that underlie it, those are going to be presented in the same manner where obviously they're all going to be charged. It's possible that there'll be a conviction of certain discrete offenses that are inside the same time period and therefore not permissible. And those sorts of decisions will have to be made with respect to improper dual convictions. I don't think it forces, in this situation, the prosecution to elect in advance because we don't know. They don't know for sure what the evidence will prove at the end. The mere fact that there would be proof beyond a reasonable doubt at the end of both does not also justify this. If we read carefully the Craig case and the Scott case, there was substantial evidence for purposes of appeal for both. The way the court stated the opinion, there was sufficient evidence to support both of them. But they couldn't stand because nevertheless...
Was the holding in Craig motivated in part by the perceived need to avoid double punishment?
I don't think that's an accurate read at the end of the day, and I think it's important we discuss that for purposes of stare decisis here. Craig should be read to be a multiple conviction case, and it specifically has been in every case that followed it. Now, Hess did refer to Craig with respect to this multiple punishment discussion. However, that case has itself been read to be limited to that particular context of multiple punishment thereafter in every case that's looked at. Importantly, too, the Marshall case, which followed in 1957 after Hess, 1955 was Hess. In 1957, you have Marshall. And Marshall, it didn't specifically deal with the issue at hand, but the discussion of the unitary construction of the offense was important to the holding, and therefore it was not dicta. They restated the rule from Craig without the use of the term punishable. So they restated the same thing from Craig, and they said, where a single act of intercourse is committed in circumstances that more than one subdivision of Section 261 is violated, there is but one offense of rape, not one punishable offense. And thereafter, we see that even in Collins, for example, the Attorney General side, that case specifically rejected the argument that Hess had overruled Craig in any way. And when we get to the further developments in the statute, you do have the 1970 change, which basically made one part of 261 now no longer a rape offense, put it over to 261.5. And we flow down from there, we get to 1980, part of this exacting scrutiny of the statute at that time, which also did not reveal any concern about multiple convictions. You have legislative commentary at that time, which talks about the definition of rape. Again, here we are, well after Craig. And it says, this is Exhibit 1, page 16, from the judicial notice materials. Existing law provides two definitions of rape. First, rape is defined as an act of sexual intercourse accomplished under any of the specified circumstances, including force, violence, or specified threats, with the person, not the spouse, of the perpetrator. Second, rape is defined to include an act of sexual intercourse with the spouse of the perpetrator, accomplished under force, violence, or specified threat. So here you have the legislature, well after Craig and these other developments, and after the change in 1970, moving statutory and relabeling it to 261.5, indicating pretty clearly that it just saw two basic definitions of rape globally placed into these buckets, so to speak, one dealing with a spouse, one not dealing with a spouse. And
okay, can I return you to the practicalities again, if your theory is the correct one? Suppose the prosecution does not elect to provide to charge in alternative counts. What then? So there is a charge of rape. Assume that through either the information itself or preliminary hearing or other means, the defense is given adequate notice of what facts are going to be proven or what theories of rape are going to be alleged. And there are two, right? It could be any combination that the Attorney General here has mentioned. The jury returns a general verdict of guilty on rape. What is the court supposed to do at sentencing?
Well, if there are multiple circumstances, and this is a situation, so I understand clearly, where it's a general verdict that could be based upon any one of a number of circumstances,
Right.
none of which necessarily had to be unanimous. Is that what you're saying?
Exactly.
Okay. As far as sentencing is concerned, I guess if it's a situation where there were multiple circumstances involved and that was sufficiently proved to the trial court for purposes of the evidence being developed, that could certainly be relevant to the sentencing. I mean, it's a triad, low, middle, upper.
Wouldn't there be an Apprendi issue?
Yeah, that's an Apprendi problem.
Additional fact finding? I don't think only if, well, I suppose if the trial court were to step outside of what was proved in the court, but I'm not suggesting that.
The whole purpose of Apprendi is that the jury is supposed to make those findings, not the trial court based on, that's what all the argument was about in Apprendi and all of its progeny.
Sure, I understand. Well, was thinking about it from the perspective of just focusing upon the proof that was developed at trial, and that being all the trial court could rely upon. If we're talking about stepping outside of those boundaries and speculating about some other circumstance, then I think it would be an Apprendi issue there as well. I had conceived that as a potential set of problems when I was thinking about how this would be dealt with, and that's why I had thought, hey, we already have existing instructions that deal with alternative counts. We do have a result at the end of the day if the jury makes a mistake and goes ahead and returns the two verdicts, which it shouldn't if it follows the instructions.
But the problem is that in theory, right, even if you have alternative counts, the jury could be divided, right, beyond a reasonable doubt. All are convinced beyond a reasonable doubt. They just differ as to the theory or the circumstance as to which applies and affects the case. So what do? I mean, from a sentencing standpoint, you have the Sixth Amendment, which it's not even a question of choosing the lesser triad, because even the lesser triad is not supported by a jury verdict beyond a reasonable doubt. Let's say it's divided 6-6, it's only supported by 6 jurors. So those facts have been found only by 6 jurors. So that's not a basis for sentencing either, right? Neither the upper or the lesser, or the greater or the lesser triad would be available to the court.
Right. I think that in those instances, both from the perspective of looking at what the jury would do in the first instance if it were to follow the instruction and just return a verdict on one count, and in the context where that doesn't happen and they return 2 verdicts and the judge is stuck with dealing with these different convictions, we have to trust the process. We have to trust that the jury is going to be responsible with its duties in making those determinations.
Well, I'm not exactly sure that I agree with your initial premise.
Okay.
It is against the law to rape a woman who is unconscious. It is against the law to rape a woman who is so intoxicated that she can't give consent, essentially, as it is defined in the statute. The evidence may prove one or the other, or the evidence may prove both, right? I mean, that's why we're here.
Sure.
So for you to say that the jury shouldn't return a verdict on both counts, depending on what the evidence is not the way the procedure works in the trial court.
Procedurally, however, if we're looking at from the perspective of what the legislature has defined as a unitary offense, and if it's construed as such, that's what we're restricted to. We have the exact same set of problems or potential issues that arise in the other context where multiple convictions are prohibited, and it becomes then a policy issue for the legislature to resolve to the extent that there are concerns they're aware of, anomalies. Because with the continuous sex abuse case, you could certainly have and probably will have evidence that would support the underlying discrete sex offenses and the continuous abuse, all established in the same proceeding and therefore theoretically available in a normal process that we would conceive of for guilty verdicts on both. And then, as that instruction states, 3516 and 1120 CalCrim, it gets into this issue specifically, referring back to 3516. It says that, look, you should probably instruct the jury in advance about this trial court, but if you don't, then you're going to be left with multiple convictions, and you'll have to just decide which to overturn, which to vacate. It does not give any guidance, and I'm not here to say that that's going to make it simple. All I'm here to talk about is...
Well, an argument could be made that the comment to the instructions doesn't give any guidance because it's not the job of the people who write the instructions to give guidance. It's their obligation to follow the guidance given by us. And that's why we're here.
Sure, and we presume that the construction of those comments is based upon the guidance that's coming from the courts. I would assume we have to make that conclusion in looking at what the instructions say. And certainly they're not binding principles of law or anything, just from a practical standpoint in dealing with these issues that arise. At the end of the day, we're in a situation where it becomes a legislative judgment. And I think it's important, too, to look at the case law on which the Attorney General has relied for purposes of argument, which is relying upon what we hear, some sort of just legislative silence as being weak. I mean, those cases that were dealing with things like in the King case, the Colbrus rule, that was on the books for 10 years, and it was roundly criticized the entire time as illogical, absurd, grotesque, and such. We don't have a situation like that here. There it would have made sense for the legislature to presume, be aware of, that this was going to be taken care of in the court system and soon, because the courts recognize it as a problem. We have this long history of the courts establishing that is the proper interpretation of the offense. So we have gotten to a point now in the history where it becomes a legislative matter. And to the degree that there are concerns along these lines, the ones that have been voiced and discussed, it's a legislative matter. So there's either an underlying reasoning of which we're not aware. Maybe they're not aware of their reasoning. Maybe they're just holding on to it. Perhaps there's not a rational basis for this. But I think that all the activity can do nothing other than support where we're coming from here. And that is that obviously they're aware of these things. They react all the time to lower court decisions, not just decisions from this court, but Court of Appeal decision after decision. Boom, the legislature says, we don't like that outcome. We also have circumstances where the legislature has specifically taken action to engraft into statutes an allowance of multiple convictions because the Court of Appeals were holding contrary to the way that they wanted it to be read. We have to infer from that and apply properly these canons of constructions and presumptions that we've relied upon in case after case to conclude that the legislature must want it to remain this way. The revamping of Section 262, which is 1993, that happened. 1993, years after Craig and these other cases which show unitary construction, that leads to the principle that we can't avoid too, that where a statute is framed in language of an earlier enactment on the same or an analogous subject, and that enactment has been judicially construed, the legislature is presumed to have adopted that construction. So that's also consistent with what was said in 1980 about how the legislature saw this as two basic definitions of rape, globally defined, where the circumstances fall under spouse versus non-spouse. I'm not here to say that that is necessarily not subject to any criticism, but we could criticize the legislature's policies with respect to the other prohibitions of multiple convictions, not just in the sex offense context, but in every context where they've done that, because anybody could make an argument that it would be fair or more just that we allow all the convictions related to continuous sex abuse circumstance to stand. But the legislature has made that determination. And perhaps in the rape situation, it has to do with this very severe stigma that follows from being labeled a rapist, which was specifically recognized when the 1970 action was taken to move that out of 261 and no longer a rape offense at all, not even call it rape. So they're sensitive. That shows they're sensitive just to the label of rape. And so I think the concerns that arise out of these cases and the concerns that the Attorney General has noted all assume that we're dealing with a separate and distinct offense and don't give credence to stare decisis or these presumptions that we're required or that history teaches us to apply in contexts like this. And I also just wanted to touch on if the court were to get to that point and conclude that it nevertheless should supplant the current interpretation with the entirely unprecedented one that's presented now, it cannot fairly be applied to Mr. White. It simply cannot. If we look at the King case, That shows you how it should play out in the King case, despite how horrible everyone thought the Colgrove rule was. That was not retroactively applied, that particular decision, despite the fact that there was a legion of cases criticizing the rule as totally flawed. The court found that that was still the law. However bad the rule was, that was the law, and it would be unfair to apply it to the defendant. We don't have anything like that here. We've never had anyone, any scholar, any judge, any court, as far as we know, come out publicly and say, this is a bad situation that needs to be rectified. There's been no dissension whatsoever, with the exception of in the last few years, the Attorney General has made these arguments, and then even only equivocally, as we've seen, with going back and forth about what the interpretation should be, because you can't get away from this history of case law, which brings us to where we are today and requires that we follow that law. However wise or unwise we might be able to think it be, that is where we are left now, and the rest of it is an argument for the legislature. The Attorney General has taken his case to the wrong forum, essentially. Does this court have any more questions?
Thank you, Mr. DiGiuseppe.
Thank you.
Thank you, Your Honors. I want to quickly just address the alternative counts. And as Justice Corrigan pointed out, this is not a situation of alternative counts. And that's what 3615 is designed for, is where you may have committed receiving stolen property or you may have committed theft, but the two are sort of inherently inconsistent. You either stole it or you received it from the person who stole it. And that's what 3615, the CalCrim instruction, is designed for, is where you either committed a crime this way or you committed it this way, but you cannot have committed it in both ways. The situation with respect to rape is just fundamentally different in that you can have committed the rape offense under multiple subdivisions of 261. So instructing a jury, not just that they have to pick one, but that the defendant is entitled to a not guilty verdict on the other one, I think perverts 3650 and uses it in a situation
Could I ask you about this? We've spent a lot of time talking about this aspect, which I agree is puzzling, to say the least. Does the Attorney General believe that this is a very serious problem, pragmatically speaking? I mean, I assume that your position in Gonzalez was, these are multiple offenses because... well, I don't know if this is really the because, but in light of it being multiple offenses, the Attorney General did not believe it was a big burden, right, to have to prove individual circumstances of oral copulation beyond a reasonable doubt unanimously to a jury. That is true in the rape context, is it not, as well? In other words, I'm trying to get a grasp on how practically significant this set of problems is.
The practical significance, I think, became apparent when courts of appeals started striking convictions and we started losing explicit factual findings made by juries because the Court of Appeal in this case, they did not consolidate the counts. They struck count 2 with respect to rape of an unconscious person. That factual finding is eradicated from the record. The same thing happened in Gonzalez, and the same thing happened in Smith as well. And I think that's when this problem sort of became apparent, which also probably explains why Craig's lay dormant for so long, because the problem here becomes apparent when we start striking convictions and we lose the ability to use the other conviction should one of these fall on appeal. And the other problem is we have no way of predicting ahead of the appellate process which one of these cases might fall victim to.
Tell me how this works. If there were a special verdict, or I don't even know if it requires a so-called special verdict. You can tell me if I'm wrong. But if the crime is charged in alternative ways and the jury returns factual findings on both, right? Or one or the other. In what sense, but let's say it's both, in what sense need one set of findings be struck? They're just not used, perhaps, in sentencing because of the unitary nature of the offense. So presumably if the crime has been proven to the more severe degree, right? Then whatever the upper triad would apply. But why does that make the other finding disappear? Would that be a necessary consequence procedurally of sentencing on the basis of the more severe circumstance?
I see that my time has expired.
Yeah, so you may answer the question.
No, I don't think procedurally that would be required to strike one of those special findings. And I think special verdicts in this context probably deals with most of the issues that have arisen in the sense that it would preserve the factual finding, assuming you have unanimity as to one or the other or both.
Right.
But I think the court has already identified that there's another situation, another possible situation, which is that you do not have unanimity, and you get 6 on one and 6 on the other, and
Is
you
that
still
a big?
have.
I guess that was my original question. Is that a big concern for you? As you've seen a lot of these cases, Attorney General has a broad vantage point. Is that a big concern, practically speaking?
Yes, I think that is a big concern. And perhaps the situation in this case doesn't best demonstrate that in terms of intoxication and unconsciousness. But something like developmentally disabled victim, who we have to prove that that victim is legally incapable of giving consent, that can be sort of a gray area, and forcible. And rape by force.
Do you lose a lot of oral copulation convictions because of our decision in Gonzalez?
I think maybe I'm misunderstanding the question.
Well, Gonzalez holds that each of these are separate offenses. So proving the circumstances with each would have to be proven beyond the reasonable doubt, unanimously in each instance. I'm asking you, is that a big problem?
No. Then I think I did misunderstand the question. I apologize. No, I think to the extent that we charge these as separate crimes and prove them unanimously, that's not a big concern. I think the concern arises if the court were to conclude that this is one offense for which we can proceed on different theories, and a unanimous there's no unanimity requirement. That's where the issue arises, because we can be left with a bare rape charge without a unanimous verdict as to which theory the jury agreed. And with respect to how evidence is presented at trial, that's a very real issue, I think, that prosecutors face in terms of they're not always sure how the evidence is going to come out at trial and what evidence jurors will find persuasive and what evidence jurors will not find persuasive. So with that, I think just in summation, the elements here are exactly the same as the elements in oral copulation. The punishment distinctions here are exactly the same as they are with oral copulation. Those are the two most persuasive indicators that the legislature intended these to be treated as different offenses. Thank you.
Thank you, counsel. Matters submitted. We stand in recess.
All right. Court is now adjourned.